back on the record in case number 2022-00402. Morning, Mr. Ember. 1 second, Mr. Malone, my screen's not working yet.
No problem.
Okay. All right, Mr. Malone, I think you had some Mill Creek 1 questions.
Yes, Mr. Chairman, thank you. I want to take a step back, though, because something was rattling around in my head last night. When you were answering questions from the Attorney General's office yesterday about the 111B, 111D issue about it being final, can you explain to me? I couldn't really. I'll let you explain first, and then if I've got an additional question. Why is it treated as final right now?
Okay, so the greenhouse gas rule as proposed is a very challenging rule. And the fact that there's 3 rules in one makes it challenging as well for us to talk about in here. The EPA didn't do us any favors there. But
Mr. Ember, sir, speak up, please.
boy, so from a 111B standpoint, 111B is performance standards for new units, in this case electric generating units. 111B becomes final as proposed in a way. For new units, the EPA looks at it and says they don't want companies to race in and submit new permits under an old standard, so to speak, once the new one comes in as proposed. So the EPA treats 111B as the basis for any new permitted units after it's proposed. And that's explained in the rule itself as it came out earlier this year.
So, making sure we're speaking the same language, I think what you're saying is that when it's a proposed rule and it's put in the Federal Register in an effort to make sure somebody doesn't go out and stick a shovel in the ground, it's effective as of the date that it's proposed, subject to obviously being final and then litigated.
I agree with that assessment.
Okay.
For the 111B aspects of the rule.
Okay.
Now, 111D,
I just want to be clear, Mr. Ember, you're just saying it's a line in the sand once it's proposed. You can't rush out and in 3 days build a power plant and then wait and say, oh no, it's under the pre-rule because it wasn't finalized yet. Is that effectively what you're saying?
effectively for 111B, yes.
Thank you. All right, sorry.
No, that's great. No, because I was having a hard time reconciling. So now we're speaking the same language. So we agree, though, that ultimately, once the rule reaches finality, it's going to be subject to litigation, and we don't have any idea. I should say, we have ideas of where it may finish up, but we don't know for a fact what's eventually going to happen with the rule.
I agree, we do not know what's going to happen with the rule, but I will note that from a 111B perspective, for natural gas, the first phase is an efficiency standard, and I think we chatted briefly, but the new units that we're proposing do achieve that, we expect will achieve that standard.
Okay.
Phase 1.
Thank you. That kind of clears up what I had on that question. I asked you some questions yesterday about construction permitting, the permitting process related to the NGCCs that are proposed. If the permits are litigated, you said the company would have to decide to take the risk to move forward not knowing, and I think it was in context to what do you do if somebody files a lawsuit after you do get approval for the permit. And I guess where I'm going with this is, what's the risk to the ratepayers at that point?
I'm
In
sorry,
other words,
can you
if the
explain someone files a lawsuit? I don't.
Well, I mean, if for example, and I'm not going to pick on, for example, if the Sierra Club were to say that that this is inappropriate for you all to move forward with construction of the NGCC for, I don't know, whatever reason, or KCA, for that matter, comes in and says that. At that point, can you identify the risks the ratepayers would be exposed to by delay of, for example, the NGC moving forward?
So the first risk that comes to mind would be a compliance cost risk. You know, if we were not to proceed with our compliance activities and had to find power somewhere else because we didn't achieve the compliance needs of the thing, there'd be a cost to that. If the permit process or the construction process was stayed, you know, there's costs related to that could be impactful to the ratepayers. I'm not sure.
I'm not perfect about my questions, but one of the other things that I was thinking through is that to the extent the permits are litigated, would that create a risk with the firm transportation issues as well with those contracts? Or do you know the answer? If you don't, that's okay.
For the firm transportation of gas?
Correct. In other words,
I would have to defer to Mr. Schramm or others.
Okay.
But, you know, contracts are contracts.
right.
I have to deal with force majeures or whatever. That's outside of my scope here.
Okay, I understand. With respect to Mill Creek 1 and Mill Creek 2, consistent with Senate Bill 4 and the way this has happened, that you have to receive commission approval to retire Mill Creek 1 and Mill Creek 2. If you don't receive that approval, what permitting actions would be required to continue to run these units?
Okay, so for Mill Creek 1, we chatted a little bit yesterday about our KPDES permits through the Kentucky Division of Water,
Yes, sir.
our discharge elimination or our outfall permits to the Ohio River. KDOW has delegation authority from the EPA to oversee those actions. So we would have to step back and work on the KPDES permit from Mill Creek 1.
Okay.
We would have to petition to address 316 from the, Section 316 of the Clean Water Act as it relates to Mill Creek 1's operation. We chatted a little bit yesterday about 316B. That's related to the intake of water from the river. And that draws in the concept of possibly needing a cooling tower, as been discussed by my colleagues earlier.
Right.
So that would be one aspect of the KPDES permit for Mill Creek 1 that needs to be addressed. The other aspect of the KPDES for Mill Creek 1 would be related to the 2020 effluent limitation guideline revisions. Okay. The 2020 effluent limitation guideline revisions require additional water treatment of the wet FGD wastewater. We would have to renew our permit with respect to addressing those limits from a permit perspective again. So Mill Creek 2, I do not recognize, as I'm sitting here right this second, air or water permit issues on our existing permit that we would need to address.
Okay. So I recognize, obviously, there's some issues with Mill Creek 1 but right now, there's not an issue with Mill Creek 2. Is there a way to run Mill Creek 2 and Mill Creek 5, the gas plant, to operate simultaneously?
Yeah, no, so, you know, my previous response was specific to our existing permits.
Okay.
And so, under the construct of our new permit application that is imminently pending through the Louisville Metro Air Pollution Control District, that permit, as applied, would not allow us to operate Mill Creek 1 and 2, or either one, with respect to the operation of Mill Creek 5 as proposed. So the answer, no, we would not be able to operate the combination of those 3 units.
Why?
The permit application contemplates and basically accepts an enforceable retirement of those units. That enforceable retirement is to allow the emissions from those 2 units to be used, so to speak, in the permitting process for the new natural gas combined cycle unit. So, you know,
Let me deconstruct that a little bit.
sure.
Okay, the permit, the original permit for Mill Creek 5, the new gas plant, when was that submitted, the request?
It would have been at the same time as the CPCN application. I think it was December of 2022,
Okay.
Subject to check.
Okay. Okay. Does an SCR on Mill Creek 2 change anything relative to permitting?
Relative to, I'm sorry, which permit do you want to talk about?
If you put an SCR in Mill Creek 2, does that change your analysis relative to the ability for Mill Creek 2 and Mill Creek 5 to operate simultaneously?
No, it does not.
Why?
NOx is the emission, nitrogen oxides, is the emissions that are being addressed by an SCR. NOx is only one of the criteria pollutants that need to be addressed in the new source review, potential for significant deterioration, netting calculation process. So addressing NOx only does not eliminate the need to do all of the PSD calculations in netting.
So you're, okay.
Well, before you come to your next question, Mr. Long, I'm just gonna ask you, Mr. Ember, I know that you play in a different sandbox than many of the rest of us.
I'm sorry, I'm having trouble hearing you.
Yeah, you play in a different sandbox than many of the rest of us, at least,
Understood, I'm sorry.
at least when I use acronyms, I know that at least 2 other people in the room know what they
Yeah.
mean. I can't promise when you use acronyms that any of the 3 of us are gonna know what you mean.
Understood.
So things like PSD, if you could just spell out
Sure.
for us, the NSPS and GHG, I think we can get, but there are gonna be some others that you mentioned. If you could just spell them out for us, that'd be appreciated.
Your Honor, may I
Apologies.
approach and move his mic up a little
Yeah,
closer?
that would be great. Thank you, Mr. Ricks.
Okay.
So what does PSD mean?
Potential for significant deterioration.
Thank you. Mr. Malone?
Thank you. So the way I took your answer, Mr. Ember, was to mean that, and tell me if I'm getting this wrong, but what you're telling me, I believe, is that we can't, that you can't run Mill Creek 2 even with an SCR and Mill Creek 5 because of the potential new GHG rules? Or am I wrong?
No, that would not be, that would not be a
I
tie.
heard you say NSPS, and that's why I'm trying to.
No, not directly, no.
So what's the, what rule, I understand the NOx, but what else is there?
So as we permitted, our application for permitting, we performed that and submitted it in the construct of a netting permit, netting out the emissions. If we were to attempt to operate or permit Mill Creek 2 to operate with Mill Creek 5, we would have to start our permitting process all over again.
But it could be done.
You could start that process all over again.
Okay.
I'm not convinced that you're going to get a permit in that manner.
What are the risks?
What are the risks? So,
I should state that another way. What are the obstacles potentially to getting those so that we're clear and we're speaking the same language?
So Jefferson County is in a non-attainment area, so we'd have to address the non-attainment process with new source review. But in reality, the biggest risk is our ability to comply with all the other rules that are going on right now. In particular, the National Ambient Air Quality Standards and achieving local attainment.
So that, you're referring to the non-attainment with the Louisville Board? Is that what you're referring to?
That is one, yes.
Okay. You said something earlier about 316. I want to go back to that. The 316 issue. My understanding is there's an issue with the Division of Water Quality. Was there a possibility that you all could have done a study that could have eliminated the possibility of needing a water cooling tower on Mill Creek 1? Can you talk about that 316 in that context? Do you know what I'm referring to?
Yes, I understand. And you pose that in a manner that the study could eliminate the need for a cooling tower. And I'm not sure I agree with the phrasing of
Fair
that.
enough, that's fine.
So, as I've mentioned, this year, we applied for, and received a new permit. In the previous permit, KPDS, the discharge permit, we had an obligation to perform studies under the Clean Water Act's 316B requirements.
Okay.
In that 316B, you can request an exemption
Okay.
if you're going to retire the unit. And going back to Mr. Beller's testimony, we've been in the process since the 2020 ECR filing, I believe it was, and operating and planning our business accordingly, that we were going to retire Mill Creek 2 in the 2024-2025, I'm sorry, Mill Creek 1 in the 2024-2025 time period. So in preparing the permit application, we worked with the Division of Water here and submitted a notice with our permit application that we were going to retire Mill Creek 1 on that timeline. And in doing so, we exempted ourselves from performing some of the studies required under the 316B. We did some of the studies as required, but there are some that were not required because of the exemption piece.
Okay, let me back that up. If you didn't go the exemption route and you did the studies that the Division of Water Quality asked you to do, is there a potential that there would be no need to retrofit a cooling tower on Unit 1?
performing those studies, we expect we would have had to have implemented a cooling tower for Mill Creek 1. It is yes, we expect we would have to install a cooling tower for Mill Creek 1.
I understand that you all expect that, but is it possible the outcome of this study could have led to a different result?
The studies would have to be performed. Given my knowledge of that unit and its operation and its configuration, a cooling tower would be needed to eliminate the fish impingement issues, the velocities at the face of the intake structure. So yeah, I fully expect that a cooling tower would be needed.
How much was the cost of the study?
Order of magnitude,
Yes, sir.
6 figures, low 6 figures.
And I take it, like I said, I don't want to do this dance with you much longer on that issue, but obviously it seems like there's a possibility that the study could have come out and demonstrated that there wouldn't be a need for that cooling tower. It's possible. If you can just acknowledge that.
The likelihood is extremely low.
Okay. Okay, I got you. Gent 2. Are any permitting actions required to continue operating Gent 2?
So, on, what is the timeline that you were talking about here?
Let's say between now and 2032.
Between now and 2032? So we just received a KPDES permit. Those are renewed every 5 years. So we would have to renew another KPDES permit in that period of time. Title V permits, which are our air permits, need to be renewed every 5 years. I want to say I'd have to, subject to check. We submitted our Title V permit in here. I don't remember what year. It's been recent, the last year or two, that so we'll have to renew that. But
Okay.
over that period of time.
So, I mean, just so we're clear, do you foresee any significant obstacles to running Gent 2 with or without an SCR?
Should I? Well,
It's kind of a broad
into the
question.
future, the answer is yes.
Such as?
Such as. So. Can you restate the question for me, please?
Yeah. Are there any permitting actions required for the installation of an SCR on Gen 2? I'll just ask you a different question.
Yes, there are
Okay.
permitting actions.
Such as?
We would have to revise our Title V air permit to install a SCR on Mill Creek 2.
That's, okay. And just so the commissioners understand, and Louisville's got this, there's the non-attainment issue there. That's not the same with Gent 2, correct?
Local attainment is not a issue with Gent 2.
Okay.
However, Gent 2 does have cross-state air pollution rule-related concerns related to NOx.
I'm going to ask you a broad question. How many, to the extent you know, I mean, rough numbers, how many coal plants have been shuttered or decommissioned in the last 5 to 10 years?
That's a number I don't know.
Okay, but would you agree with me that there's a significant amount?
There have been many coal-fired retirements over the last several years.
And you just brought up something about downwind, upwind. I took it as, you know, some of the cross-state issues.
Certainly.
Would you agree with me that from a big picture standpoint, that relatively speaking, to the extent there are less coal plants actively running, that issue that you just brought up may not be as significant as it was, for example, 10 years ago?
I do not agree with that statement.
Why?
Twofold, starting with number one. Yeah. The ozone standard has changed. And the ozone standard continues to be, and when I say the ozone standard, the ozone standard for the National Ambient Air Quality Standards, it's required to be reviewed every 5 years. So there's downward pressure on NOx related to the ozone standard for National Ambient Air Quality Standards. Number two, the compliance process and the modeling under the compliance process takes those retirements into account so far. And today, you know, we're addressing the standards with the status of the electric generating unit fleet across the country as it stands. So we need to be forward-looking, I think, with respect to our compliance activity in that, with respect to that rule.
But what does that have to do with Gent?
So, trying to figure out. So, under the National Ambient Air Quality Standards, there's a requirement for ambient air to be measured at 70 parts per billion. For areas that are not in attainment, they can petition the EPA directly to ask states that significantly contribute to their non-attainment to reduce emissions in support of their non-attainment. So specifically in our case, Kentucky has been determined to be a significant contributor to the state of Connecticut. And as a significant contributor, we, as a state, get pulled into the cross-state air pollution rule aspects of the Clean Air Act and the National Ambient Air Quality Standards. Gent, not having an SCR, which is a selective catalytic reduction, the technology that is used to reduce noxious emissions, Gent does not have the reasonably achievable control technology to reduce NOx under the the guides of the Clean Air Act. And so, with direct respect to Gent, the significant contribution for the state of Kentucky to others polls concern for NOx reductions to units like Gent.
Okay. That's.
I'm sorry, Mr. Malone, I still don't understand it. If I wait to ask the question, I'm not gonna remember it.
No, that's fine.
NAX, if I call it NAX, is that okay?
Yeah, that's fine.
Okay,
Yeah.
great. NAX gets updated on a periodic basis, similar to other rules.
Correct.
Is it gonna be updated this year or next year?
The EPA's unified agenda has the ozone NAX being updated in the spring of 2024, so next year, yes.
Okay.
And I'll add to that, the EPA has a KSAC is the name of the organization. It's the Clean Air Scientific Advisory Council. It's an advisory council to the EPA, and I think it was August 18th. KSAC, through the EPA, published some comments that were suggesting the standard would be proposed in the 55 to 60 part per billion level. The standard today is 70, and several areas across the country are struggling to achieve 70, including Jefferson County. And to think that the standard will be reduced even that much increases our pressure with reducing NOx across our operations.
Okay. And has there been any recent reporting on the result of that panel's recommendations? Any expectations that EPA's timeline is different?
The press and utility information that I read does not have anything that tells me otherwise.
Okay.
That would come out next spring, and that it's likely to be lower.
All right, so like take a big step back, because I really want to understand this. You're saying there's an interplay between NAX and Casper, is that right?
So, yes,
Okay.
Casper is a function of NAX.
Yeah, we'll get into details in just a second. So big picture though, you're saying one is a contributor, like, okay, let's just, big picture, because I read this. Downwind states complain that pollution from upwind states contribute to their inability to meet local attainment. Is that basically what you're saying? That's the interplay with that Gent has with local non-attainment in other places?
Yes,
Okay. Two different seasons, right?
yes, the
The local
ozone
non-attainment-
season and non-ozone seasons, is
Yeah.
that?
Okay, so but is that the same, like is the Louisville NAX time period, that summer, I think it's 7 months, is that the same everywhere that the EPA requires for local attainment of ozone?
No.
Okay. All right, so the NOx that we're talking about, that would require Good Neighbor Air Transport, it literally has a half a dozen names, but the Good Neighbor rule that is being discussed in this case is a 5-month summer, correct? The one that would require SCRs for Mill Creek 1, 2, and JIT 3 to comply with, and for which the SIP and FIP in Kentucky, or as it relates to Kentucky, are both state.
Yes, the cross-state air pollution rule itself, the construct of NOx trading and those things are May through September in 5 months, yes.
For the purposes of local non-attainment for NAX, is Louisville upwind or downwind of JIT 2?
I'm not trying to be funny. The answer is yes.
Well, let me ask it, no,
I'm sorry.
I'll ask this directly. Do you all have evidence or expectations? Or are you aware that the Louisville Metro Air Pollution Control Board has evidence or an expectation that Gent 2's operations during the summer is a material or is a contributor at all to Louisville's local non-attainment under NACS? Are you aware of evidence?
I have not evaluated it, to an absolute manner, but I have observed and looked at data and wind direction type things that would show that Gent could contribute to Jefferson County, possibly. But,
Well, I guess-
I don't know the answer directly.
And you don't know is a fine answer. I'm not asking you to testify to something you don't know. I'm just curious, do you have an expectation that it's a material contributor to Louisville's non-attainment? And if you don't know, that's okay too.
I don't know for certain, but it's possible.
And so I just want to make sure I understand, big picture, your responses to Mr. Malone is that the interplay or the Gent 2's, the, local non-attainment for NACS as it relates to Gent 2 comes into play not necessarily with local non-attainment related to Jefferson County, but as to its contribution or purported contribution to local non-attainment in other jurisdictions. Is that right? Is that what your answer was earlier?
Yes. That said, Louisville Metro Air Pollution Control District, in attempting to resolve its non-attainment issues, could look even within the state for reductions
Could
in the
look-
same manner.
Could look
For
within the
NOx
state.
reductions.
You're saying they have effectively a long arm that can extend beyond Jefferson County and requiring pollution controls in other places in the Commonwealth? I'm not asking for a legal opinion, I'm just, are you aware that, are you aware of conversations that that's a power that they have? Let me ask it this way, let me withdraw that
Yeah, well,
question, because it's still kind of a legal question.
It's
Are you
correct.
aware, do you have any expectation that the Louisville Metro Air Pollution Control District Board, I always forget the district part, sorry, that they have is Louisville Gas and Electric and Kentucky Utilities concerned that the Louisville Metro Air Pollution Control District Board will require controls at Gent 2 related to NOx emissions?
No, not necessarily.
Thank you. Mr. Malone?
Thank you. And this harkens back to the question I raised earlier with you about the shuttering, decommissioning of lots of coal plants over the last 10 years. The modeling concern that the chairman raised with you is where I was, part of where I was going with that. With respect to the Clean Air Act and this attainment issues and whatnot, it certainly seems to me less coal plants in place could certainly change the modeling, couldn't it?
Theoretically, less coal plants changes the modeling.
And when would that happen? When would we know?
I'm struggling to
When,
answer that
when would
question.
new modeling arise? Do you know?
Sorry, multiple agencies are involved with respect to different modeling here, so I need more specificity.
That's okay. We'll move on.
Okay.
You've answered the question. Backing up, can you explain why an SCR was installed on Brown 3 but not Mill Creek 1, Mill Creek 2, and Gent 2?
Well, it's subject to check. I believe the SCR at Brown 3 was related to a new source review related consent decree.
Can you explain that?
So that was a little bit before my time in this role. I do not recall the exact basis of the consent decree, but you know, for whatever reason at the time, we had to implement.
Can I'll walk you
Please
through.
let him finish his answer.
Go ahead, I'm sorry.
But yeah, to the question, so the SCR at Brown 3 was tied to a past consent decree. Mill Creek 1, 2, and Gent 2 SCRs were not installed, although we may have had CPCN to install some of those. I don't recall exactly which. I know Gent 2 we had approval to install, but we were able to comply with the NOx requirements, the cross-state air pollution rules and clean air interstate rules back in the day related to NOx, and so the company chose a more economic compliance path by not installing those and operating our fleet in a compliant manner without those costs that would have impacted the ratepayers.
Backing up to Brown 3, tell me if, I think we're speaking the same language. I understand that, I guess the EPA stepped in and alleged violations of permit violations and NSPS review occurred. Can you talk about, do you know whether or not, with respect to the SCR that was put on the plant, was that something that was paid for by the ratepayers, or was that paid by the company? Do you know?
I believe there was, well, I'm speculating on what the answer was. I was not involved in the CPCN processes for those.
Okay. Okay. All right, I want to ask you some questions about life extension costs. Can you explain what they are with respect to the coal plants?
So I think the life extension costs are outside the purview of my environmental regulatory expertise here today.
Okay. Who would be the right person to talk to about those?
So I think Mr. Wilson may have spoke some about it, Mr. Beller, possibly Mr. Sinclair, but Mr. Beller may be the best person.
Okay. So. I've got some questions for you about Scope 3 emissions. What are they?
Okay, so Scope 3 emissions. So we're getting into environmental, social governance type line of questioning
Yes, sir.
there. Scope 3 emissions is a term for emissions related to the activities of your suppliers, so to speak. So in the construct of an example, we have coal delivered to our facility via a train. So the train's emissions related to conveying the coal to us would be Scope 3 emissions.
Can you reference that, use that example relative to the gas plants that you're proposing?
Scope 3 emissions for gas plants could be related to methane as it is emitted in the process of extracting and transporting gas.
As we sit here today, I know well, I should say we don't know the answer, but is it possible, obviously, that the Scope 3 emissions relative to methane, for example, with your example, are something that could potentially impact how the gas plants are run and the cost structure?
As we sit here today, the answer is no. Those emissions do not impact the cost structure of the projects.
In all fairness, though, obviously, as we sit here today, right now, the greenhouse gas is not exactly final either yet. Correct?
So as we sit here today, and the greenhouse gas rule is not final, but as it relates to the 111B new unit, we do have to take that into consideration.
Do you have any familiarity with the 2021 IRP?
Yes,
Okay. What involvement did you have relative to that and suggesting that in reference to the carbon capture at that point?
so I was the environmental witness for that case.
What changed between 2021 and 2022 with the resource assessment with respect to carbon capture?
What changed?
Why was it included in 2021 and not 2022?
Okay, so in 2021, we were performing an IRP for a 15-year assessment. At the time, the Biden administration was very clear on its objectives to end fossil fuels by 2035 and implement CCS as part of that objective. As we fast forward a short time to the resource that we put forth here, the market did not support that technology.
Did you, when you say the market, what's the basis for the market? What's your basis for that statement?
I think Mr. Sinclair could probably respond better about
Okay.
the RFP process and so forth.
Okay. When I was reviewing your direct testimony, Mr. Ember, page 5 had a footnote 6, and I want to ask you about that. And I don't want to sandbag you. I've got, what it is, it's comments that the companies submitted on the FIP that you kind of referenced in your testimony as well, a little bit.
Okay.
And it has to do with the Good Neighbor Plan. This
Sure.
was before the Good Neighbor Plan was proposed at that point.
Mhm.
And the way I took it is, as I read this, is it said basically, you alleged there were certain technical flaws in the proposed Good Neighbor Plan. And basically, you were asking for additional flexibility and time. In other words, you were asking for delay, is what I took it as, in the implementation of the Good Neighbor Plan. These were submitted, as I read these, June 21st of 2022. The CPCN got filed December of this action, December of 2022, having reviewed the whole situation, I know the Attorney General then filed a motion which was granted at the Sixth Circuit Court of Appeals, issuing a stay of the Good Neighbor rule with respect to Kentucky. My question is this, is the companies were asking for delay of the Good Neighbor Plan in June of 2022. Did the Attorney General's office reach out to the companies and perhaps you about supporting their request to stay the Good Neighbor Plan after this filing?
Are you asking after the filing of our comments?
Did the attorney, well, let's just ask it this way. Did the Attorney General's office reach out to you to see if you all would support their request to stay the Good Neighbor, their request to stay the Good Neighbor rule with the Sixth Circuit Court of Appeals?
Yes, the Attorney General's office did contact us about supporting their stay request.
Okay, and why did you not do that?
So, as in our comments that are referenced there in the footnote, we acknowledge the EPA has the obligation to address the National Ambient Air Quality Standards attainment issues and implement a cross-state air pollution rule. We did ask for some modifications to that rule, as per our comments there. We did not engage with the Attorney General's office. We felt, I believe, that our concerns were being addressed through other mechanisms at the time. And so we did not engage, we did not put forth an affidavit in support of the Attorney General office at the time.
Well, that's kind of what I was trying to figure out is you filed comments in June saying you want to delay it. CPCN gets filed. The Attorney General's office reaches out thereafter and says, hey, we're going to file a motion to stay the Good Neighbor rule. Why? What was the change of course? Why didn't you all continue? What changed?
We still agree that the Good Neighbor Plan has challenges, but it does not eliminate the fact that a Good Neighbor Plan or something like it needs to be implemented for attainment of the National Ambient Air Quality Standards. We acknowledge that there's a need for NOx reductions, and we have a plan put forth to address those NOx reductions. We think,
Well, and the reason I
Sorry, let him
go ahead.
finish saying,
Sorry.
please.
Because I think Big Rivers supported it, as did EKPC, and I'm just wondering why the companies, I don't know.
Asked and answered,
Okay,
objection.
it's fine. On Brown 3, is there any issue, continuing permitting issue, inhibiting the ability to run both the gas plant proposed and Brown 3, the coal plant?
So as we've put forth our Title V air permit, very similar to Mill Creek 1 and 2, we used netting in the potential or new source review and potential for significant deterioration process. And as we've proposed, we would not be able to operate both units at the same time.
Couple more questions. When I brought up,
I'm sorry.
Go ahead.
It's the same thing as Mill Creek. Every answer you give is that you set up the situation through the way you filed your permit, but I don't think that was the question. Is there something keeping you from doing it? You cited the reason. Is there anything other than the way you filed the permit? Let me ask you just brass tacks. Do you feel like you can get a permit for approval of either of the combined cycles at Mill Creek or Brown without the retirement of Mill Creek 1 and 2 and Brown 3?
We can go through the process, starting over, right? We can go through the process of doing a full new source review PSD permit. That process would require us to do additional air modeling, and air modeling that would, the results of that would have to show that we are not significantly impacting attainment for criteria pollutants in our areas. And apologize for the complexity. PM could be, particulate matter could become a problem with obtaining full PSD permits going forward.
PM of what size?
PM 2.5.
Okay. So you ran anything? You ran any studies of Mill Creek 1 and 2, or either of them running a non-ozone season with no SCR, giving them an SCR, Gent 2 having an SCR? Let me ask it this
Yeah,
way.
from a-
I'll withdraw that.
sorry.
Let me just ask you a very direct question. Did you all model anything other than what you're proposing as a CPC in this case, which is the retirement of Mill Creek 1 and 2, Gent 2, Brown 3, Hafling 1 and 2, and Patty's 12?
Mr. Wilson and his team performed many iterations of but I,
Economic and financial models. You were talking about modeling for. I'm asking for. I've asked Mr. Wilson lots of questions about his modeling. I'm asking about the modeling you were just referencing. Did you model anything other than the proposed CPCN and the SB4 retirements in this case?
So, from an environmental compliance perspective, we did not run any modeling of air compliance and with respect to the National Ambient Air Quality Standards and things. By performing the netting process in our permits, we don't have to do those air models. By netting out and reducing our emissions, we improve, theoretically, the air quality in our surrounding areas. As such, the modeling is not required to be performed. If we were to go down the path of PSD, a full PSD permit, we would have to do that modeling.
So, no modeling from an environmental perspective was done because the proposed CPCN and retirements in this case negated the need to do that modeling. Is that right?
No air modeling was performed.
Okay. But the concern you just stated of having to go through that process is what you're saying is the hurdle from even considering those alternatives. Is that right?
That is a hurdle. I will also throw in that in doing a full PSD permit, we would have to perform best available control technology assessments for emissions controls on the units that we're proposing. And those That backed analysis, best available control technology analysis, would likely result in the same air quality control systems on the natural gas units, but it would also lead to different and more emissions limits on our units within our Title V. Those emissions limits would, performance and reporting and compliance requirements would add additional risk and cost to the projects.
But all those things, well, let me ask it this way. Do you feel you've provided those considerations or concerns around all?
Sorry, I'm not following your question.
So those are all considerations that you all took up in making the decisions that led to this case. Would you agree with that?
Again, I'm not understanding what decisions you're asking about.
Okay. Where to put things, why to file this permit this way because of concerns about filing it the other way. Let me ask it this way. Are you saying that all of these responses to Mr. Malone, like if we did that, this would be the downside of it. If we did this, this would be the downside of it. You knew all of that before you were asked those questions today, right?
I'm very familiar with what we've put forth and how we've gotten here, yes?
Yeah, okay. So like if the combined cycle is put at Mill Creek and Mill Creek 2 is up, we can't file the same type of application that we would if Mill Creek 1 and 2 were retired and Mill Creek 5 was built. Like you've known that before today, right?
Yes.
Okay. Did that go, just that knowledge, did that factor in to whatever your all's ultimate decision to propose this case was? Let me conceptually ask a question. You all previously tried to build a combined cycle at Green River, right?
Yes.
That's a brownfield site, but there's nothing else there. There's no generators that could retire that you could offset through this Title V permit process, right?
No.
Okay.
That's not true. No.
That's not true.
No, there were generators there. There
Okay.
was a Title V permit, and there was an opportunity for netting at the time.
At the time, I'm sorry. I'm saying here. Like
I'm
there's
sorry.
nothing at Green River now. So if you wanted to build these 1x1s, either one of them at Green River, that would be a different type of permit than you have proposed at Mill Creek and Brown, right?
Absolutely.
Okay, that's what I'm trying to get. That you all knew that, and did the fact of hey, we could put it at Brown or we could put it at Pineville or wherever else you all have land control, right? And we know that there are differences with the transmission system, and that can be studied. But when it comes to your job, you knew, it sounds like, hey, if we're thinking about retiring Mill Creek 1 and 2, and that's the driver of this need, we could actually just put this new Mill Creek 5 at the Mill Creek, this new combined cycle in the Mill Creek station, and not even have to file a new permit, just amend it and do the netting. Right?
Yes, and keep the cost as low as possible for our ratepayers in the process and comply with the rules in a timely manner. The ability to comply with the rules in a timely manner is impacted by the time it takes to get a PSD permit, by all means.
That's great. I guess what I'm trying to just have an appreciation for, having read your direct testimony in this case, is you've participated in a number of cases, either at providing testimony or I'm sure support in front of the Public Service Commission, right?
Yes.
Okay. Have you, in a CPC, and have you ever heard that, we look at alternatives to the proposal? Have you ever heard that before?
Yes.
Okay. And that you all provided through the case alternatives. Mr. Wilson modeled a few dozen of them, right?
Yes.
Okay. As it relates, though, to the it's not really qualitative, but the impact, the either feasibility or ability or practicality of the environmental impacts of alternatives. Do you feel like you address those in your direct testimony in this case?
I think the answer is no. My direct testimony is with respect to the projects that we've put forth for approval, not for alternatives. So I think the answer is no to your question.
Well, and that's why, I guess that's why I'm really trying to ask to have an appreciation for what you all have actually looked at before you walked in the door on the environmental side and what you all have done since then. Because there have been hundreds at this point of data requests asked in this case, right?
Yes.
Yeah, yeah. And in a 2-week turnaround, for the most part, the companies have responded to every single one of those data requests, I think, fairly fully, done all of the modeling, the financial and economic modeling, provided us lots of data requests, and you've responded to lots of data requests, right?
Yes.
Okay. So a lot of the data requests that have gone out have been, why didn't you do it this way? Why didn't you do it that way? You know, what's the impact of this? And a lot of that has been from the perspective, and it's the questions, not the responses, have been from the perspective of what would be the reliability impact of this, or what would be the, change on the present value revenue requirement of that proposal. Would you, that generally, that's really a statement. That's an unfair question to ask. That's just a fact. Like, folks have asked a lot of those questions. It's hard, though, for me to sit here and say that after this, 9 months of this case being tendered, I still don't have an appreciation of the feasibility, ultimate feasibility of any of the proposals. Because it sounds like every alternative proposal has risks insofar as the companies haven't looked at the feasibility from an environmental perspective of those alternatives. Does that make sense? Does that concern make sense the way I described it?
Yeah, I understand.
So let me ask this question. It's easier to make an example, right? Yesterday, maybe the day before yesterday, at some point, I asked Mr. Wilson about this fictional, I made up an example about what if the unit retirement and unit additions looked like, and I think I had Mill Creek 1 retires, Mill Creek 2 has no SCR, Gent 2 has no SCR, Brown 3, retire, not retire, doesn't really matter. You build the solar, you build or buy the solar, you get the solar PPAs, and you build the battery. Like, what would be the loss of load expectation of that? Summer, winter, summer being the, which one is it? The good neighbor rule summer, right? The 5 months, not the 7 months of non-attainment. And the present value revenue requirement compared to the proposed. Right? He can run that study. Right? He can do the financial impact of that. He can tell me the loss of load expectation. But do you think we have the evidence in the record to have do you remember providing data requests that would give us a good appreciation of the feasibility of a scenario like that from an environmental permitting perspective?
I think the record does address that in a way. And what I'm getting to there is that, all of the models that Mr. Wilson ran addressed NOx and our compliance with activities going forward. So from that perspective, I think our modeling did. As it relates to the construct of where we build new generation, perhaps not. But, assessed sites and the costs related to the sites. The infrastructure is discussed by Mr. Beller, and put forth projects that would have been the most advantageous to the ratepayers from a cost and compliance perspective.
Well, so here's a great example. There was a table, maybe you didn't actually see, but there's a table in Mr. Wilson's testimony, table 5 in his SAW1 that walked through like the LOLE of the current system plus DSM. And then it had in blue it had whatever the change was from the previous portfolio. And one of them was that he and I discussed yesterday. It just took, instead of gent retiring or gent staying on, it did gent retiring or gent with SCR. It just said gent no SCR. And then it gave us the LOLE of that. I guess what I'm trying to have an appreciation for is if he did a present value revenue requirement calculation of that, financial calculation of the impact of that portfolio, you, based on your response there, feel comfortable that that would pick up these qualitative concerns that you were expressing to Mr. Malone about keeping Gent 2 on without SCR as it relates to the possibility of continued required controls due to local non-attainment in other jurisdictions?
There's a lot to unpack there. The modeling that was performed addressed the compliance aspects. It addressed the economics of the different technology implementations at the sites based on compliance. I feel we're talking around each other with respect to permitting versus technologies.
I don't feel like,
constructs.
I'm sorry, I don't feel like we're talking around each other. I guess what I'm trying to understand is your testimony, direct, I guess, data requests, all these different things you're cross-examining today. I appreciate that you're identifying the possibilities and the risks of particular outcomes. I do, and this is a statement, it's not a question. Because I feel like it's imperative that we take those into account because it's probably customers rather than the companies that shoulder the majority of those risks, right? You build a power plant, it has to be retired in 7 years. It's a significant risk. Would you agree?
If you build a power plant and it retires in 7 years,
Yeah.
but
If
what's the-
you expected the power plant to last decades and it lasts 7 years, that's tough for customers, right? It's really a rhetorical question. It's tough for customers. What I'm trying to, I guess, really ask here is, I appreciate you giving these qualitative risks to Mr. Malone based off of the scenarios that he's explaining to you. What I want to make sure is, if we need to know the follow-on qualitative risks that exist to customers for alternatives, do you feel like you've provided that in the record, or do you feel like we should be explicit in a post-hearing data request of scenarios and alternatives that we would like considered or already considered maybe from a reliability and an economic perspective? Should we directly ask those to you so that you can identify for us the qualitative risks as it relates to environmental controls or permitting or compliance?
I think post-hearing data requests to answer questions would be appropriate.
Okay, so like if this fictional thing I gave Mr. Wilson yesterday, this boom, 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 MC2, no SCR, doesn't run in the 5 months, Gent 2, all that. If we gave those to you as a post-hearing data request, you could identify to us the qualitative risks that you believe exist or are reasonably foreseeable.
Risks related to the technologies, risk related to permitting, yes.
Mr. Malone?
Thank you, Mr. Chairman.
Backing up to the questions that the chairman asked about permitting, I want to ask a couple things about that. With environmental permitting risk, does the company bear any financial risk if you all are not able to obtain the environmental permits that are required for construction of these CPCNs, of these combined cycle units in a timely manner?
I think the company bears development-related cost risks. Beyond that, I would suggest I defer to Mr. Sinclair or others on the financing.
And there's also no guarantee in getting the air permits or what's needed here, correct?
Well, I mean, I think under the guise of what we've submitted, and if our authorities follow the constructs of the rules, we should have no problem with getting air permits.
You don't foresee, from a risk standpoint, you don't see any risk in getting an air permit?
I don't see a risk in getting a Title V air permit for Brown 5 or Brown 12 or Mill Creek 5, no.
What if the commission decides that Brown 3 should stay open, or Mill Creek 1 and 2 should stay open? How does that affect wouldn't that cause a risk associated with the air permitting process?
That would require us to start the air permitting process all over again, and it then would put us at risk in complying with other rules and regulations.
Okay. Looking at your rebuttal testimony, I just want to ask you briefly about the stay at the Sixth Circuit. How many times in your career involved in the regulatory analysis have you seen a stay issued of any of these rules relative to Kentucky?
Just a handful of times, maybe.
Okay. My review, when I was looking at the declarations that were filed relative to the motion at the Sixth Circuit where the stay was granted, there's a statement from, I believe the fellow's name is Michael Kennedy, the Division of Air Quality at Kentucky. He makes a statement towards the end of his declaration that staying the final rule, and he's referring to the good neighbor rule, staying the final rule during the pendency of this litigation will cause no harm. A stay will maintain the status quo while EPA and the Kentucky Department of Air Quality can collaborate on an approvable SIP. Can you reconcile his view with your view, which I take on page 8 of your rebuttal is that the Sixth Circuit litigation is not going to have an effect on the SIP? And I don't want to put words in your mouth, but tell me, do you understand my question?
Can you reread me the statement that's
Sure.
in my testimony, or point me directly to that again?
Sure. As I look at the declaration for Michael Kennedy of the Kentucky Department of Air Quality, he said a stay, in other words, what was eventually granted by the Sixth Circuit, he said a stay will maintain the status quo while EPA and the Kentucky Department of Air Quality can collaborate on an approvable SIP. When I look at your testimony in the rebuttal, I take it as you don't think there's going to be any changes, or significant changes, I should say, to the SIP. What's the difference? Why does he look at it differently than you?
So, yeah, I understand your question. I agree with Mr. Kennedy, actually, number
Okay.
one. Number two, you said that I don't think there's going to be a change in the SIP, the State Implementation Plan, which is the guidance for us in our compliance here. What you said that there wouldn't be a change in the SIP. Mr. Kennedy says that they need to reevaluate the SIP and resubmit it. And I agree with that, and our comments to the EPA on the Good Neighbor Plan address that as well. We told the EPA that the Kentucky needed time to perform the SIP because the EPA put itself in a difficult position, actually. The EPA's made this very challenging for all of us by not responding to the Kentucky SIP in its obligated, timely manner according to the rules. Now, we can go back to, Mr. Kennedy can go back to the drawing board and redraft a state implementation plan and submit it to the federal EPA. That state implementation plan, though, must address the significant contribution of the state of Kentucky to others. And to address that, Mr. Kennedy must address NOx reductions within the state of Kentucky. And he must address them on the exact same time frame as the federal implementation plan. So Kentucky may get an opportunity through this 6th district challenge, and that's a may, get an opportunity to resubmit their SIP, and the EPA will have to evaluate it and determine whether or not Kentucky has generated adequate NOx reductions to eliminate its significant contribution to the attainment of others. But my position is, even if Kentucky goes down that path, and I hope they do, NOx reductions will still be the end result. And those NOx reductions will still be on the same timeline as the Good Neighbor Plan. And so, I firmly believe, and it is the law of the Clean Air Act and the regulatory statutes of the NAAQS and National Ambient Air Quality Standard and the cross-state air pollution rules that we will end up with NOx reductions in the state of Kentucky for achievement of attainment by 2026.
And that conclusion's based on what?
That conclusion is based on the Clean Air Act, which is, I don't think, going away, the subsequent National Ambient Air Quality Standards that are within the Clean Air Act, and the cross-state air pollution process that is within the NAAQS. All of those have been around for many years, have been debated, legally, and have withstood challenge time and time again. So yeah, my basis is on my expertise and knowledge of the Clean Air Act, yes.
But in all fairness, I think we are speaking the same language. You did admit, obviously, that Kentucky's going to get a chance to revise the SIP, and as we sit here today, we don't know what that's going to be. I understand you're making an educated guess, but we don't know what the final result's going to be.
Objection, there's no question. Counsel's testifying.
We don't know what the result of the SIP is going to be, correct?
We do not know what the end result of the state implementation plan would be, but we do know of the obligations of the EPA, even as the EPA is under consent decrees itself to address these SIP processes. We know that the process must continue, that NOx reductions will be the end result, so that Kentucky will not be a significant contributor to other states. I mean, it's the statute, the regulation, proven over and over again.
Well, just a more general question. What I'm trying to reconcile in my head is the companies have taken the position that the Good Neighbor rule is going to be, almost a fait accompli, whereas the NSPS is not going to be enforced. So, how do you pick and choose?
That's a great question. So, again, I talked about how the Clean Air Act, the National Ambient Air Quality Standards, and the Good Neighbor, or the Cross-State Air Pollution Rule are well proven and defended within the courts of law. On the flip side, for the greenhouse gas rule, there's been continued question about the EPA's authority to regulate CO2. okay? Now, recently, the Inflation Reduction Act had a definition in it related to carbon and the EPA's rights to regulate CO2, but historically, that's been a legal question that's been quite clear for some time. The Clean Air Act has, I think it's 6 criteria pollutants. We talked about particulate matter. We talked about ozone. There's 4 others, not necessarily relevant here, but none of them are CO2. So CO2 is not a criteria pollutant. It is not defined under the Clean Air Act as a hazardous air pollutant either. So, again, lots of debate over whether or not the EPA has authority to regulate it. But it is very clear the EPA has the authority and obligation to address cross-state air pollution rules. So that's the difference from my professional opinion.
Well, did you think the stay was going to get issued?
Objection calls for legal conclusion.
Okay, that's fine.
I'm actually gonna overrule the objection because I think if what Mr. Ember at this point hasn't provided, if Mr. Ember has provided plenty in that regard, and I think if he knows the question or has an opinion, he can give it, but he's given plenty of opinions as to his expectations of the outcomes of litigation on this front. So, Mr. Ember.
I'm not a big betting man, so to speak. Did I think that a stay was going to be successful? I would say it was a fighting chance, but it was by no means a slam dunk. I mean, most of us put it at a 50-50 really at the time.
And do you ascribe significance to a stay?
In this specific case, I subscribe and so we're talking about a stay to this denial of the state implementation plan. This is not related, there's not a stay to the FIP necessarily. A stay to the SIP denial, I don't think there's a dramatic significance from a technical compliance perspective and timeline for the need for NOx reductions, no.
No further questions.
We'll take a short recess until 10:20, and we'll come back with you, Mr. Osterloh, and you, Mr. Winter.
Chairman, can I ask a question before we go off there?
Sure.
At about the 9:50 mark, you commented that the commission might ask a post-hearing data request. And I didn't know if that was a hypothetical or if the commission will ask that.
The commission will ask a significant number of post-hearing data requests, so, yeah.
I just
Are
wanted to
you
make
asking, you're gonna ask if we don't, is that what you're saying?
Yes, sir.
I-
Yes. Okay. Thank you.
No need to do duplicitous work, Mr. Cook.
Thank you,
We'll
sir.
be in recess. Okay, we're back on the record. It's been indicated to me that witnesses Goggin and Gravatt may need to participate in the hearing remotely next week. That'll be fine. I do ask that you get with Ms. Vinsel or Mr. Funsell or Mr. Bellamy and discuss to make sure that in addition, or similar to witness Summer, that they're able to check preferably by the end of the day today with our IT staff to make sure that they're able to participate through our GoToMeeting system, because I do not want us to have IT issues that preclude our ability to bring them in as witnesses in the event that they need to be remote. All right. Mr. Nguyen, Mr.
Yes.
Osterloh, you have questions for Mr. Ember?
We do, Your Honor. Thank you. Good morning, Mr. Ember.
Morning.
Want to ask you questions related to your rebuttal testimony. It starts on page 12, where you explain certain environmental, potential future environmental requirements outside of or independent of the company's potential compliance under the Good Neighbor Plan. So specifically, with respect to Mill Creek Unit 2 and its operations within Jefferson County. Do you recall that in your rebuttal testimony?
Yes, sir.
Okay. You mentioned that the Jefferson County is currently non-attainment, correct, for ozone, for NAAQS ozone?
Yes.
Okay. And that the Louisville Metro Air Pollution Control District, along with the Division of Air Quality, have filed a petition with EPA to redesignate the attainment area, the local area, as being in attainment. Is that correct?
That is correct, I'm aware.
Okay. And with your work experience at LG&E, you're currently the Director of Federal and Environmental Compliance, is that correct?
Environmental and federal regulatory compliance. Sorry
Okay.
for the
And
complexity.
how many years have you worked in the environmental area for the companies?
So directly in the environmental affairs area, 7+ years. Prior to that, I spent 15 years in the project engineering group. I'm afraid to say that, but given all the questions from project engineering yesterday, doing environmental projects, so working with the development and permitting and compliance strategies for environmental things. So in total, 22 years.
Okay. And during your time with LG&E and your responsibilities overseeing the environmental compliance, you've had a lot of interactions with the Louisville Metro Air Pollution Control District and their processes, correct?
Yes, I'm quite familiar.
Okay. And you mentioned it a little bit in your rebuttal towards the bottom of page 12, or the middle part of page 12. Starting at lines 11 through 15, could you just read that for me?
Starting at line 11,
Yes.
with Louisville Metro Air Pollution Control District, paren, quote, LMAPCD, end quote, and paren, comma, an air pollution control district created under KRS Chapter 77 and established by resolution of the Jefferson County Fiscal Court, comma, now Louisville Metro, period. Responsibilities of LMAPCD include issuing and enforcing permits for sources of air pollution and monitoring the ambient air to ensure that it meets federal air quality standards, period.
Okay. You mentioned in that sentence the monitoring of ambient air to ensure that the county meets federal air quality standards, correct?
Yes, that's
Okay,
what my rebuttal states.
Are you aware of the monitoring stations that LMAPCD operates within Jefferson County?
I am aware, yes,
Okay. There are 5 monitoring stations within Jefferson County that's operated and controlled by LMAPCD?
I don't remember the exact number, but I trust that 5 sounds correct.
Okay. Are you familiar with the EPA regulations that govern the siting, the operations, control of those air monitoring stations by LMAPCD?
I'm familiar.
Okay. So there are certain federal regulations that have to be complied with, even by LMAPCD, in terms of its operations and maintenance of those monitoring stations, correct?
Yes, that is
Okay.
true.
As well as any data collected from those monitoring stations, there's quality control and quality assurance procedures and protocols that's established by EPA regulations with respect to those air emissions data.
Yes, and I'll add to it, LG&E and KU follow some of the similar QA, QC, quality assurance, quality control requirements.
And during your time with LG&E in the environmental compliance area, do you attend any of the LMAPCD's board meetings, monthly board meetings?
Yes, I try to make them every month. It's quite a social event.
Okay. That's a loose term. Your Honor, if I could approach the witness.
May.
And we've emailed the exhibits to counsels for the parties as well.
Including staff counsel?
Yes.
Thank you.
Yes. Mr. Ember, what's being passed out is, and it's entitled Louisville Metro Air Pollution Control District. PM, at the very first page, it's PM 2.5 monitoring report, August 2023.
Would you like to mark this, Mr. Nguyen?
Yes, can we mark it as LMG 1? Do you have that exhibit?
Yes, I do.
Okay. Is this, and I'll call this a report, is this a report that is normally produced by LMAPC district staff to provide to the board at the monthly board meetings?
Yes, this is, and I believe you guys publish it on the internet monthly as well.
Okay. And even though the first, and it's not numbered, the first page states PM 2.5 monitoring report, this is an air quality control report from the LMAPC district staff. Is that correct?
I agree, to the best of my knowledge, that's how all this comes together, yes.
Okay, so you have, even though the first page shows PM 2.5 monitoring, there's also, if you flip to page, unnumbered page 3, it has 8-hour ozone monitoring report, and it also has, trying to count the pages, I think it starts on page 6. There's a report on sulfur dioxide as well. Is that correct?
That is correct.
Okay. So this is the report. So let me step back. For the NAAQS, the National Air Ambient Quality Standards, there are criteria, and those criteria pollutants are, what are those criteria pollutants?
Particulate matter, ozone, SO2 are 3 of them, as in this report. I think mercury, CO, and NOx, I believe, subject to check.
Would it be lead
Lead,
and nitrogen oxide?
Yeah, NOx is nitrogen oxide
Okay.
in my world, sorry, but
Okay.
yeah, mercury, I mixed up lead and mercury,
Okay.
apologies.
So just want to focus on the ozone, the NACS ozone, the ground level ozone. And it's been mentioned that the Louisville area is in non-attainment, correct? And the Louisville area consists of Bullitt, Oldham, Jefferson counties in Kentucky, as well as Clark and Floyd counties in Indiana, correct? Okay. If you take a look at, on page 3 of this report, that shows the 8-hour ozone monitoring report, and it's dated August 2023. So the initial paragraph, the initial sentence states, this report summarizes ozone data collected by automated equivalent method, ozone analyzers located within Louisville metropolitan statistical area. Do you know what the automated equivalent method, what that reference is?
I'm familiar with the term, I couldn't explain it. no.
Okay. Just in general, is that the term reflected by EPA for the general collection and reporting that is accepted by EPA for, in this case, ozone monitoring, ozone data collection?
Yeah, the collection of the data from, automated collection from the sites that you mentioned earlier.
Okay. And this, the chart below shows the 2023 8-hour ozone maximum values and exceedances through August 9th, correct? It's at the top of the table.
It says through August 9th, but apologies, the table ends on August 4th.
Sure. But the label says August 9th.
Yes.
Okay. And if you look at the column where it says, the second column, where it says number of 8-hour exceeds, do you see that?
I do.
Okay. And at the bottom, it sums up the number of 8-hour exceedances in the Louisville metropolitan statistical area through August 4th as being 38. Is that correct?
Yes, it is.
Okay. And then the number of days exceeded on the third column shows that there's been 12 days that's the Louisville metro area has exceeded the ozone standard. Is that correct?
Correct.
Okay. And those two columns are basically shows the summary of the remainder of the columns that has the monitoring stations listed at the very top. So for instance, you've got the Charlestown, Clark County, Indiana, that reflects a monitoring station in Clark County. Is that correct?
Correct.
Okay. And then the remainder is just the other monitoring stations. And the numbers in red, for instance, if you go to the Cannons Lane, Jefferson County, can you let me know how many number of exceedance that monitoring station shows through August of 2023?
So for which column, I'm sorry?
For the Cannons Lane,
Cannons Lane, yeah,
Jefferson
my
County?
backyard, 8.
Okay. And then the last row, it shows truncated fourth maximum. What does that last row indicate?
So truncated fourth maximum. Truncated means that the decimal places are just truncated. It's not rounded, it's just, you eliminate the decimal place in total. Fourth maximum is the fourth highest of the red items in that table. Those red items being the number for a day of exceedance, or a data point of exceedance. So the fourth highest would be a 75 in relation to, well, I'll stop there, 75.
Okay, you can go ahead, fourth highest. So for the Cannons Lane, Jefferson County, it shows, the measurement there shows 75, correct?
That is correct.
Okay, and that's 75 parts per billion, correct?
That is true.
Okay, and the current NAAQS ozone standard is what? What's the limit on that?
70 parts per billion.
Okay, and that was
And that's-
established what year?
That was established in 2015.
Okay. So the current 2015 NAAQS ozone standard is 70 parts per billion. And if you're looking at the bottom row where it shows truncated forth maximum, this is the value that shows whether or not each of the monitoring stations are either in excess of the NAAQS ozone standard or below the NAAQS ozone standard, correct?
That is correct. Specifically for the design value that's used in the year, the actual attainment is tied to a 3-year average. So if 75 maintains the design value for the year, meaning there is not another higher number that comes into play besides 75, that would get averaged with the design value from 2022 and 2021 to depict actual attainment to the area.
Okay. And we'll get to that in just a minute. But as of through August 9th, or the last data point is on August 4th, how many of the monitoring stations within the Louisville metro statistical area shows the design value being above the current 2015 NAAQS ozone standard of 70 parts per billion?
All but one of them, so, I mean, on the table 7, including the ones in Indiana, 5 in, or 4, or yeah, it would be 1, 2, 3, 4, 5 in no, that's not right. 1, 2, yeah, 5 in Kentucky there, if I'm adding that correctly.
Right, so all except for the Buckner-Oldham County monitoring station
Correct.
shows in excess of the 70 parts per billion current level. If you can turn to the next page. Well, let me skip that. Turn to the page after that. The bottom graph where it shows the 8-hour ozone design value trend chart. Do you see that?
Yes, I do.
Okay. And it shows for the last data point, it shows for the years 2021 through 2023. What's the annual design value for that particular time period?
The chart depicts 72
Okay.
parts per billion.
And then from the 2020 to 2022 time period, the design value for that is,
It is 70.
okay. So the trend is increasing, correct?
Unfortunately, yes.
Showing that the Louisville metropolitan statistical area is not in attainment for ground level ozone NAAQS based on the 2021 through 2023 data. Is that correct?
The data as it stands today does contend that fact, yes.
Okay. And we've had pretty bad weather this week too as well, correct?
It's not been good from a ozone perspective, I agree.
How is ozone formed?
Ozone is formed in the atmosphere with NOx and volatile organic compounds. They combine, chemically react with sunlight as an accelerant. So those two pollutants mixing in the atmosphere over sunlight generates ozone.
Okay. Are you aware that the Louisville Metro Air Pollution Control District issues air quality alerts depending upon the air quality index?
Yes, I am aware.
Okay. Are you aware of any air quality alerts that have been issued by LMAPCD for this week?
Well, I'm embarrassed to say no, but I've been in here focused on this activity this week. I'm sure I could ask my staff and they would tell me the number.
And in terms of, this has been discussed before, in terms of the current 2015 NAAQS ozone standard, you mentioned earlier with respect to EPA opening up consideration of that standard, of the current standard, correct?
Yes,
Okay. And you mentioned that the CASAC, the Clean Air Scientific Advisory Committee, having recommended a standard, proposing a standard being 55 to 60 parts per billion. Is that correct?
that is correct.
Okay. In Jefferson County, what's for a point source, a stationary source, what source is the largest emitter of NOx in Jefferson County?
I believe the answer is Mill Creek 2 right now. I say believe because Mill Creek 1's not been operating as much, but between the two of them, I would say they're number 1 and number 2.
Okay. Do you know what would be the second most NOx emitter in Jefferson County, be it point source or got the term now, on-road source as well?
Yeah, I would say it's transportation, vehicle traffic.
Okay. So in terms of the NAAQS, EPA's consideration of the current NAAQS ozone standard, how often does EPA, let me back up, is EPA required to, under the Clean Air Act, required to undertake review of the NAAQS ozone standard?
Yes, it is.
Okay, and how often, what's the time period that EPA is required to undertake that review?
Every 5 years.
Every 5 years. So this is just the beginning of the process for EPA to review the NAAQS ozone standard?
I think yes. Yes, the answer is yes.
Okay. You also mentioned that could be other environmental regulations that EPA could consider as well in terms of its review under NAAQS, the other criteria pollutants, the different standards with respect to those criteria pollutants. Are those standards required under the Clean Air Act to be continually reviewed by EPA?
Yes.
Okay. Is the fine particulate PM 2.5 NAAQS, is that required to be reviewed by EPA?
Yes.
And how often is that required to be reviewed?
I believe it's every 5 years.
Okay. Is or has EPA undertaking a review of the current PM 2.5 standard?
Yes, there's a proposed standard update right now.
Let me ask you, what is the current
The
PM
current
2.5
standard
standard?
for PM 2.5 is 12 parts per billion, I think it's 12 is the number.
Okay, is it 12
Parts per
microgram per cubic meter? Is that it?
That's better, thank you.
Okay. So it's 12.
12, yes.
Let me refer you back to the report, LMG Exhibit 1. On the first page, it shows the PM 2.5 monitoring report. Do you see that?
First page, sorry.
Yes.
Yep.
Okay.
There.
PM 2.5 monitoring report, August 2023 is the title at the top. The large table in the middle where it lists PM 2.5 monthly averages tracking table for 2013 through 2023. Do you see that?
Yes.
Okay. And can you, for for 2020, for 2022, give me 1 second. Okay, can you turn to the next page, the second page, the page after this, the unnumbered second page?
Yes.
The middle table where it says PM 2.5 annual means and annual design values, do you see that?
Yes.
Okay. On the left column, it shows the site name. Do you see that?
Yes.
Okay. Can you take a look at the Durrett Lane? And that's
Sorry. I just sneezed there. Can you
Sure.
start over?
Sure.
Apologies.
The site name that has Durrett Lane, do you see that?
Yes, I
Okay.
do.
Is Durrett Lane a site of an air monitoring station that LMAPCD operates and maintains?
Yes, it is.
Okay. For the others as well, Algonquin, Cannons Lane, and Watson's Lane, those are also sites of air monitoring stations in Jefferson County?
Yes, they are.
Okay. For Durrett Lane, can you go look across that row and under the annual design values for the years 2020 through 2022, what is the annual design value for that 3-year period?
10.2.
Okay. So is it fair to say that the most recent full 3-year data for PM 2.5 level within Jefferson County, the Durrett Lane would be reflective of the attainment level for PM 2.5 in Jefferson County?
Yes, it would.
Okay. And the current standard is, what is the current standard again for PM 2.5?
12.
Okay. And you mentioned that EPA is considering reviewing the PM 2.5 standard currently, right?
I don't know if I said review, but they have proposed a
Okay.
new standard. Oddly, they proposed a range of 9 to 10.
Okay. So it's under draft, the rule is under draft right now. EPA has taken comments on that proposed rule. And you mentioned that the range that EPA is considering is between, what again, I'm sorry?
Officially, 9 to 10, but in this proposal, they requested comment down to 8.
Okay. Has the comment period ended?
Yes.
Okay. So if the final rule reflects the proposed draft of, say, on the upper limit of 10 micrograms per cubic meter, how would that impact the company's compliance with respect to PM 2.5 in Jefferson County?
So the company's compliance with PM 2.5 is directly tied to its Title V permit and our direct operations. Secondarily, if the area is deemed in non-attainment, the area, Louisville Metro Air Pollution Control District, would have to prepare a state implementation plan to submit with means and methods to bring the area back into attainment. Louisville Metro would be looking to all sources, both stationary like Mill Creek and non-stationary like vehicle traffic or airplanes and other things, to try and find mechanisms and methods to have enforceable reductions that could bring it back into attainment.
Those are all the questions I have. Thank you, Ron.
We'll take no recess. We'll just take a short break while council board transitions.
Oh, Aaron, can we move this into,
Mr. Riggs,
No objection.
this entered as LMG1, is that right, Mr. Riggs?
Yes.
Or Mr. Irwin?
yes, thank you.
This is from the federal reference method and federal equivalent method, right?
It's just-
No, take your time.
Crowded space.
Yeah. Mr. Riggs, while we're waiting here, just want to confirm. I think we have Mr. Sinclair next, followed by witnesses Bevington, Isaacson, and Conroy, is that right?
Yes, that's correct, Your
Will you
Honor.
be presenting the remainder of the witnesses?
I will not, forgive me, Your Honor, I will be presenting Mr. Sinclair,
Okay.
and then Ms. Wimberly will be presenting Mr. Bevington and Ms. Isaacson, and
Okay.
Mr. Ingram will be presenting Mr. Conroy.
Thank you. Counsel?
Thank you, Your Honors. Good morning, Mr. Ember. My name is Joshua Smith. I represent Sierra Club in this matter. Just a couple of threshold questions for you. I think you identified your position with KU LG&E. I just want to make sure that in that position, you're not only responsible for understanding various environmental regulations that govern the generation fleet, but you have some understanding of the compliance methods for doing so.
Yes, absolutely. I spent, as I mentioned, the first 15 years with LG&E and KU, developing and implementing air quality control systems.
And in that role, is it fair to say that you keep track of the various rulemaking dockets that EPA establishes, typically on regulations.gov? Are you familiar with that?
I'm familiar and I do my best. It's a landslide.
Yeah.
There's a lot of info.
But generally speaking, the agency keeps what's called a docket generally, and in that docket, they have various technical documents that support various compliance methods. Would you agree with that?
Yeah, absolutely. Yes, I'm familiar with the docket.
And you've been at the hearing throughout, is that right?
Correct?
I did want to start with Mr. Wilson's direct testimony, which I'm sure you're familiar with. Is that correct?
Yes.
Because I think it's helpful in sort of framing and setting the table for some of the questions that the commission has had and what we might go through. Do you happen to have access to that? And if you don't, I can share my screen. I wanted to show you Table 13 in that report. I can share my screen if that's easier for you.
Please.
Okay.
Mr. Ember, is the monitor to your right turned on?
Yes, it is.
Okay. And then if anything that you're shown by Mr. Smith is too small on that very old monitor, the very new big one is available to you. So, Mr. Smith, if you want to share. Let me try to.
Give me 1 second here, Your Honor. My computer is working a little bit slower than I would hope.
Is this the table 11 from SAW 1?
It is, Your Honor.
Maybe easier for Mr. Lovecamp. Table 11 from SAW 1.
Okay.
I'm sorry, Your Honor, the table in question,
The table on the screen is table 11 from SAW 1. You'll have to ask Mr. Smith, Mr. Riggs. I just knew it from sight is all. So,
What was the question? I'm sorry.
do you want the original or the updated
Um,
one? Does it make a difference?
It doesn't make too much of a difference. I just want to establish kind of one basic thing with it.
I assume we mean upgraded. It's the response to joint interveners 2-60C.
Sounds right, I'm not certain.
Okay, that's
This
fine.
is
The
a
May
enormous
update.
record.
May 4th update, yeah. Okay. Mr. Smith?
Can we validate what I'm looking at so I know that I'm on the right document, please?
So I'm looking at table 13 from SAW-1. Table, is that what you're?
Yeah. Can you, I'm sorry,
It's page 74, I think, of the.
what's the title on it beyond that?
It's called Stress Testing Results, PVRR difference from
Okay,
best
thank you
case.
for the clarification. Thank you.
Um,
Oh, sorry, I need to, apologies.
Thanks for following along. And so I guess I just want to go over this very briefly. As we've talked about a number of times, the company's preferred alternative here is the least cost in virtually every scenario. Is that right? Portfolio one.
Your Honor,
That
I
is,
object. This is not within the scope of his testimony. This is another witness's testimony.
Your Honor, I just want to lay a foundation for asking a couple of questions about environmental compliance risks going forward.
I'll overrule the objection, but I'd get there quickly, Mr.
Okay,
Chair.
so it shouldn't really take too long, and so the company's preferred alternative is the least cost alternative going forward, and that involves retiring Mill Creek 1 and 2, Gent 2, and E.W. Brown 3. Is that correct?
that is correct.
Now, if we're to keep any of those units running, in general, would you agree with the premise that additional environmental compliance costs for those units would only directionally make the operation of those units more expensive?
Yes.
Okay, great. So with that in mind, I do want to kind of walk through some of the regulations we've been talking about, because I think there's been some confusion. There's a lot of interrelationships between the regulations. Would you agree?
I agree that everything is complex from a environmental regulatory perspective, and I'm happy to clarify.
I do want to come back to a couple of questions that I believe the chairman had about the docket in this case. And you'll recall a number of questions relating to citing a new CC at the same location of Mill Creek 2 and 1, and whether you could continue to operate those two existing units. You recall that?
I recall that, and when you say CC, I'm assuming a natural gas combined
Yeah,
cycle.
so it's more specifically, I guess Mill Creek 5 is proposed, correct? And you talked a little bit about the constraints on doing that. You recall that conversation?
Yes.
And so I just want to put a little bit more detail out there for you. When the company conducts that analysis as part of its new source review analysis, you talked about what's called a netting analysis, right?
Yes, I discussed it, and we performed that.
Right. And so part of that netting analysis that the Mill Creek 5 unit is premised on is retiring both Mill Creek 1 and Mill Creek 2, right?
Yes, the premise in our Title V permit application is premised on netting the retirement of Mill Creek 1 and 2.
And that helps avoid what are called the significance thresholds that would trigger further review under the new source review program. Is that correct?
That is correct.
If you continue to operate each of those units, the process is essentially evaluating the addition, the modification of the facility to include the new emissions, right?
That is correct.
So if we keep those two units online and operating, the addition of those units would exceed the new source review program's significance thresholds, right?
Yes.
And because this is in a non-attainment area, you'd agree with, you agree that the area is in non-attainment, correct?
Mill Creek area is in non-attainment,
And
correct.
because it's in a non-attainment area, it undergoes what, would you agree, is a heightened new source review compliance requirement?
Specifically called non-attainment new source review.
Right.
Correct.
And so, and even more specifically, for non-attainment areas, major modifications, and we established that if you add the CCs to the existing coal units, we'd exceed the major modification threshold. correct?
That is a true statement.
Would trigger what's called lowest achievable emission rate. Is that right?
Also known as LEAR, but yes.
Yeah. Lowest achievable emission rate is typically even more stringent than you would expect from some of the other emission control rates under the Clean Air Act. Isn't that right?
Yes.
And you'd expect at a minimum that would trigger for the existing units an emission rate that would be commensurate with SCR, right?
It's possible that the permitting process might require modifications to the air quality control systems on existing units at the site, yes.
Well, let me tease that out a little bit more, because I thought we established that if we did exceed the significance threshold, LAIR, or lowest achievable emission rate requirements, would kick in for the facility. Is that correct? And would you agree, as a general matter, for nitrogen oxides, the lowest achievable emission rate is generally commensurate with SCR technology?
I would agree, lowest achievable emissions rate for coal-fired EGU is SCR, or selective catalytic reduction technology, yes.
Okay.
I'm sorry, I'm having trouble hearing again. I hate to keep asking you. I apologize. If you could speak up.
Do I need to repeat?
Yes, please.
I do agree for coal-fired electric generating units that selective catalytic reduction is lowest achievable emission rate technology for NOx.
Okay, great. So just in that new source review process, is one bucket of risks of what we'd call SCR at the Mill Creek units. Would you agree with that?
Yes,
Okay. And in addition to SCR for non-attainment areas, there would also be what's called an offset requirement under the Clean Air Act, isn't there? Is that right?
yes.
And an offset, without getting into the weeds, we're already there potentially, but an offset requirement essentially requires the company to offset nitrogen oxide, here the relevant pollutant, nitrogen oxide emissions, with reductions somewhere else within the non-attainment area. Is that a fair statement?
That's a fair statement. Yes, it is a fair statement, yes. Offsets are required.
Would you expect that to impose additional costs on the operation of the Mill Creek 1 and 2 units?
It possibly could, yes.
Okay. And so those offsets, you'd also agree, have to be greater than the emissions, than the increase in emissions from the major modification itself, generally speaking?
Generally speaking, in a non-attainment area, we're also penalized for that as well.
Okay.
In the offset process.
Great. And so I want to move on to a couple of other environmental risks, and I want to, we'll do it unit by unit maybe, just so we can maybe try to keep things organized in a way that's understandable. You talked a little bit with one of the other attorneys this morning. Well, let's stay with the air risks first. We talked quite a bit about the Good Neighbor Plan and the risks associated with that. And I want to pardon me, Your Honor.
Sir, while you're doing that, can I just ask at a very high level, why, given the questions that are being asked from Mr. Smith and Mr. Nguyen, why put, from exclusively your perspective, I get Mr. Sinclair, all these other people have other jobs. If you're gonna propose to retire generation in Jefferson County and you have all of these, the situation is whatever it is, why would you put the replacement generation in Jefferson County?
So for a variety of technical and economic reasons. So number one, from an environmental perspective, our ratepayers have assets there. Those assets have permits. And I think it's our duty to be good stewards of those assets and utilize them as best as possible. And in this case, the Title V air permit that we have at Mill Creek allows us to follow this netting process and implement a unit at that site that utilizes the infrastructure that exists, the property that we own, the intake structures that we have, the transmission that we have. Again, as stewards to the ratepayers' assets, it's our best interest to input it there. If we were to go, and further, from a development perspective, generally utilizing brownfields are definitely preferred to greenfield sites. So there's a lot of benefit of using the existing site, and yeah, I guess I'll stop there.
Okay. So, we'll take we need to take a short recess, Mr. Smith. Apologies, but we're having some IT difficulties in the back.
Sure.
We'll just unplug and replug something. We'll go off the record real quick.
Is this going to be like 2 minutes?
Thank you, Your Honors.
Hold on one second, Mr. Smith, sorry.
Okay.
We're beholden to our technology.
Yeah.
We're back on the record. Mr. Smith, would you like to continue?
Thank you, Your Honors. And so, just to kind of pick up where we left off, putting the new NGCC Mill Creek 5 at the Mill Creek station and continuing to operate units 1 and 2 would represent a significant risk of having to install SCR at those 2 units. Is that correct?
Yes,
Okay. And if you do retire those units, you'd have significant NOx emission reductions within the non-attainment area, right?
that is correct.
On the order of a few thousand tons per year, isn't that right?
Few thousand tons is
Okay.
an order of magnitude I agree with, yes.
Okay. Now, rather than do this unit by unit, I did want to talk briefly about the E.W. Brown NGCC that's proposed. This would be Brown 12. There is a similar problem at that site. Would you agree? There's a similar problem at that site with installing the CC and continuing to burn coal at Unit 3.
There are permitting challenges for certain, yes.
And that one's a little bit different because the area is not designated as non-attainment. Is that right?
It is not designated, it is an attainment area, correct.
Okay. So instead of lowest available emission rate for non-attainment areas, you still have to comply with what's called best available control technology for major modifications. Is that correct?
Agreed?
And although they have different acronyms, generally speaking, best available control technology would be commensurate, again, with the rate you would achieve with SCR. Is that correct?
I agree with that statement.
Okay. Setting aside the permitting issue, let's set aside the permitting issues under the NSR program for adding new units to those sites and talk about just the ongoing compliance issues at each site. Does that sound okay?
Certainly.
Thanks. And I want to take them one by one. We spent a lot of time talking about the Good Neighbor Plan. Okay, and it's clear that if it is implemented the way it was finalized, Mill Creek 1 and 2 and Gent would be required to, again, meet emission rates that are commensurate with SCR by the end of 2026. Is that correct?
I would say commensurate with SCR in the middle of 2026.
And if you didn't install SCR, you provided a discovery response that the units would be able to operate maybe 8 days out of the ozone season. Do you recall that discovery response?
I do.
Can you explain how you calculated that?
It's very simple math. So can we go to that data response just to help me refresh my memory?
Yeah, that'd be great. Your Honors, may I approach?
You may.
This one
Make sure you get the report one as well. Thank you.
Mr. Ember, do you have a document?
Judge,
marked
counsel.
as SC-6?
Yes. Yes.
You recognize this document?
Yes, I do.
Can you identify it for the commission, please?
So it is stamped exhibit SC6, response to question number 1, page 1 of 2 Ember, Case 2022-0042, question 1, responding witness, Philip Amber. Attorney General's request for information.
And does this look like a true and accurate copy of that response?
Yes, it is.
I'd like to admit this into the hearing record, Your Honor.
Mr. Riggs? No objection.
Mr. Ember,
I'm sorry, I just want to be clear. As SC 6?
yes,
All right, that'd be fine.
sorry.
That's good.
And just for clarity, Your Honor, did you admit it?
Yes, that's
Okay.
what I'm trying to write it down before I
Yeah.
admit it. So, yeah, so that's fine. As, admitted as SC-6.
Mr. Ember, does this help you explain what the operation of
Yeah,
these units are?
absolutely. So, both Mill Creek 2 and Gent 2 operate today without selective catalytic reduction. They operate with combustion controls for NOx emissions inside the boiler. The resultant is a NOx from our operations at a emissions rate of about 0.3 pounds of NOx per million BTU. Under the Good Neighbor Plan, these units will be required to, they will be allocated emissions credits or allocations based on new SCR technology at an emission rate of 0.05. So 0.3 of today versus 0.05 of the future is a factor of 6. So if you consider the ozone season here in my testimony being about 150 days, 5 months, 30 days a month, just round math, simple. And then the fact that eventually there's a 3-to-1 penalty for allocations, a surrender penalty if you exceed the backstop limit. So that, your emissions would then be, or your allocations would be even 1/3 less than that. So 150 days in the ozone season divided by 6 for the differential between SCR control and non-SCR control, divided by 3 for the penalty surrender, leaves you with approximately 8 days of operation that you would get to pick and choose from to operate your unit, so to speak. And these are coal-fired units that take a fair amount of time to start. They don't start, in a matter of hours. So from an operational perspective or a generation planning perspective, as Mr. Wilson would take into consideration, that really hampers the flexibility of those 2 units.
And then, as you understand, or under the finalized Good Neighbor Plan, going forward after 2027, EPA has finalized a rule that would have dynamic recalibration, dynamic reallocation of emission credits. Isn't that right?
Yeah, the EPA is using a new concept, I would say, of dynamic budgeting and determining the allocations going forward. Today, under the revised Cross-State Air Pollution Rule Update 2021 that we're living under, it doesn't dynamically budget. I mean, we know what our allocations are this year and going forward.
Yeah.
But so, yeah, there's a flexibility and a difficulty in figuring out your allocations in the future, yes.
But it just point blank, it would be fair to say that under that dynamic budgeting construct, you'd expect allocations to just ratchet down.
Based on the mathematics the EPA has behind this very complex rule, yes, I expect it to directly ratchet down going forward. The EPA would contend there's an upside, but the mathematics, particularly for units like LG&E and KU, where we have traditionally been controlling to a very low rate of NOx, that upside is not helpful to us. We will ratchet down going forward.
Okay. We've talked, you had a couple of conversations earlier today about the ongoing stay of the rule. Do you recall that?
Discussion on the stay. Yes, and yes, I do.
Okay. In your rebuttal testimony at page 7, you note Kentucky's main arguments in opposition to the so-called SIP disapproval. Do you see
Page
that?
7,
Yeah, do you see that?
I'm on page 7.
And Kentucky's basic argument, as you articulated, is that the state didn't have adequate notice of updated modeling showing Kentucky's impacts to downwind non-attainment areas, number one. Is that right?
Yes,
And number two, a disagreement with the threshold that EPA has adopted to establish significant contribution under the good neighbor provision of the act. Is that correct?
yes,
And I think you described those basically as procedural arguments in a way. Is that a fair characterization?
yes, it's a fair characterization. I don't know if I used that term exactly in my rebuttal. I think I did, but yes, I consider them procedural.
Yeah, because if Kentucky does ultimately win on the merits on argument one, the usual course would be for the court to remand, send it back to EPA for further consideration or notice, maybe, to Kentucky of the new modeling. Is that correct?
That's true.
And/or on number two, reconsideration or explanation of the threshold. Correct?
Correct.
Now, Kentucky, in its, you're familiar with the briefing that Kentucky submitted, is that correct?
So I'm familiar with the briefing that Kentucky submitted to the 6th District Court related to the SIP disapproval. Is that what you're referencing?
Yeah, you talk about this a little bit in your rebuttal testimony.
Yes.
And just very basic point, I hope. The state actually used EPA's previous version of the modeling in developing its own state implementation plan. Is that correct?
Yes.
And in that previous version of the plan, the modeling, Kentucky doesn't actually dispute the validity of the modeling platform itself, do they?
I don't recall that being a dispute.
Okay. In any case, I think your testimony was that if the SIP disapproval is invalidated, it would be sent back for further consideration. It would not result necessarily in the invalidation of the Good Neighbor Plan. Is that right?
Yes, that is definitely true.
Okay. And so just keeping track of where we've been going, we talked about one Clean Air Act program involving the permitting of new sources in non-attainment areas and areas that are in attainment as being one bucket, so to speak, of risks associated with the ongoing continued operation of the coal units. Is that correct?
Yes,
Okay.
we talked
And
about
then-
permitting.
And then the Good Neighbor Plan represents another bucket of risks.
Yes,
Okay. Now, even if the Good Neighbor Plan were to go away completely, there is still a program called the Cross-State Air Pollution Rule that KU LG&E's units would be subject to. Is that correct?
yes, but it is a complex process, so I'll continue. But yes, for sure.
And that's a different cross-state program that EPA developed under the 2008 Ozone National Ambient Air Quality Standard. Isn't that right?
That is correct.
And EPA imposed that obligation on Kentucky because it found that Kentucky contributed to non-attainment in several other states. Is that correct?
Yes.
And in particular, New Jersey, New York, and Maryland. Is that correct?
Certainly, yes.
In those areas, New York, New Jersey, and Maryland remain in non-attainment under the 2008 standard. Are you aware of that?
Yes, I am aware.
And so that CASPER obligation, we sometimes refer to, sorry for the acronym, but the Cross-State Air Pollution Rule obligation will remain regardless of the Good Neighbor Plan's fate. Is that a fair statement?
That is a fair statement. To support the 2008 NAAQS standard for ozone, yes.
And that program is a similar trading program. I think you describe it as a similar trading program to the Good Neighbor Plan.
Well, I guess stepping back, the Good Neighbor Plan is a cross-state air pollution rule. It is. It's just a new iteration or an update or a revision to the existing 2021 revised update of the cross-state air pollution rule. The cross-state air pollution rules have been around for over a decade. They continue to be revised, and I find that, you know, even for me, having dealt with this stuff professionally, confusing how many iterations this stuff really is. So, but yeah, the Good Neighbor Plan is a cross-state air pollution rule under the NAAQS, under the Clean Air Act.
Okay, and so that's, let me follow up on that point, because in your rebuttal testimony, you cite fairly extensively a declaration that EPA filed in the Sixth Circuit litigation. You recall that?
Yes, I do.
Yeah, and this is a basic point. You said this is the latest, the Good Neighbor Plan is the latest iteration of cross-state rules. And we talked about the cross-state rule under the 2008 NAAQS. And before that, there was what's called a NOx-SIP rule. Is that correct?
Yes, yes, definitely.
And so for the better part of the last 30 years, there have been new and evolving iterations of cross-state plans designed to reduce NOx emissions.
Yeah, absolutely. Going back, I mean, the NOx SIP call was in the late 90s, and that's what drove the implementation of selective catalytic reduction across all of the units that have it within our fleet today, basically.
And so while the emission limits have changed somewhat over time, would you agree that the trading program approach is not particularly novel?
No, the trading program is not novel, not at all.
And so would you expect in some form or another EPA to continue to regulate NOx from large sources of pollution that contribute to downwind non-attainment?
There is no question the EPA will continue to regulate NOx via these same processes, and a trading program is legally proven, and it actually offers us quite a bit of flexibility. So we generally, as a company, support the NOx trading program.
Okay. And then one other point on the existing trading program. You are aware, are you aware of recent NOx prices under the existing trading program?
Define recent.
Are you aware that this last summer or last spring, when EPA proposed the Good Neighbor Plan, that NOx emission credits spiked to about $50,000 per ton?
Yes, and thank you for clarifying recent. I wouldn't have gone back over a year, but yes, I agree with your statements.
And in the EPA declaration that you cited extensively in your rebuttal, the EPA declarant in that case, in that particular instance, cited more recent prices of about $9,000 per ton. Is that correct?
Yes, that is correct.
Okay. Are you familiar with how many NOx credits each of the coal units at issue are allocated?
I'm familiar, but it is a lot of numbers, and I cannot recall them from memory.
Would you accept that each of the units are allocated in the range of 400 to 600 tons per ozone season?
Yes and no, and I answer it that way because non-SCR and SCR units are going to have different numbers. I would say our non-SCR units are probably a little bit higher right now.
The non-SCR units are allocated higher amounts.
Generally, yes.
Um,
But I mean, I'm happy to look at it.
Yeah, I just wanted to, it's just a helpful benchmark, because I think we talked about earlier, Mill Creek 1 and 2, are you familiar with their recent ozone season NOx emissions?
Recent as in the last couple of years, yes,
Last- yeah,
yes,
last-
yes.
So-
And I'm sorry, part of my confusion is making sure I'm not mixing up the Good Neighbor Plan and the existing revised Casper. So apologies for.
Yes. Okay, fair enough clarification. We're talking about the revised Casper plan.
Okay, thank you.
2008 ozone next. And so, would you accept that Mill Creek 1 and 2 and Gent 2 each emit in the range of 1,000 or so, maybe 1,200 tons per year, or tons per ozone season?
Yeah, yes, looking back, up to 1,500 or 1,800 depending, but as you look back as far as 2017, as they have in some of the calculation methods the EPA is using.
And so, in order to fill that delta, the difference between their current ozone season emissions and what they're allocated under the current Casper program, they're gonna have to come up with about 500 tons per year somehow, is that correct?
Easily, if
Yeah.
not more, yes.
So you can do maybe a back of the envelope, just for demonstrative purposes. If we assume a $9,000 per ton credit price, how much it would cost to obtain 500 credits per year per unit? You could kind of do that math if you, would you accept that math?
I accept that math speaking here today, right now. There is a lot of market pressures and changes that can occur over the period of these projects that we're talking about. So I want to be clear, we're talking about the ability to procure credits today and actually use them in the future. There's a lot of debate and discussion that could happen on that topic.
Thanks for that. But regardless of how, again, regardless of how the Good Neighbor Plan pans out, the operation of these four coal units at issue is going to continue to be limited by the existing Casper program.
Absolutely.
Okay. So now we've talked about three general buckets of risk, at least with respect to Mill Creek and Brown. The NSR permitting process, Good Neighbor Plan, and the continuing of the revised Casper program. Is that correct?
I follow your logic and agree.
Okay. And in your testimony, you also talk about another couple of risks associated with the continued operation of the units. And in particular, you talk about Section 126 of the Clean Air Act. Do you recall that?
Yes.
Mr. Smith? It is 11:58, so we'll have to keep the 126 conversation until 12:30.
Understood.
We'll take a short 32-minute recess, and we'll come back and you continue your cross-examination, counsel.
Thank you.
crossed out the first. Although I've always found 2.5 pages of my outline because it's very. Well, there is an
before you go on the record.
Oh, hold on a second.
Did I?
I don't know that I'd said that. I don't know. We're back on the record in case number 2022-00402. Is there anything we need to take up on the record as we begin? Mr. Kurtz, have you got any more direction from Mr. Collin? Okay.
Yes, he'll be in Monday morning, bright and early. He'll be allowed to go, ready to go through about 2 o'clock. He's got to then get on an airplane. Remotely, Tuesday morning, he can do until about 1 o'clock. He is the lead witness on behalf of the Florida People's Council, their consumer advocate in a rate case beginning, I guess, maybe Tuesday afternoon or Wednesday. So that's why he's unavailable. And if need be, he can be available the following week, weekends, whenever, but just not after that.
All right, I appreciate that information. All right. Mr. Smith, would you like to continue your cross-examination?
Thank you, Your Honor.
Just remind you, Mr. Ember, you're still under oath.
Good afternoon, Mr. Ember. Before we move on to section 126, where we left off, I wanted to come back to 2 other brief points. First, you'll recall, before we took the break, we talked a bit about new source review requirements and the permitting of the 2 new NGCCs that the company is proposing. Do you recall that?
Yes.
And the company, in this case, responded to 2 discovery requests and included those applications in the record. Isn't that right?
The Title V permit applications for the Mill Creek and Brown sites that include the natural gas combined cycles are in the record, yes.
And in particular, I think, do you recall responding to those in response to Joint Intervenors Request 1-1.19? If you don't recall, you don't have to go look it up.
I believe you.
Oh, okay. And so for everyone's benefit, would you accept that if you wanted to go and look at the emission calculations for continuing to operate relative, that would describe the emissions associated with continuing to operate the coal units and the NGCCs, they could go look at those emission calculations?
Yes, those emission netting calculations are part of the record.
Okay. And if I may, Your Honors, for your benefit, that's attachments 1 and 2 to the responses to JI 1-19. Thank you. And then I wanted to touch on one other point, clarification for the transport rules that we talked about. And those transport rules, just to be clear, arise as a result of EPA's resetting or revision of the National Ambient Air Quality Standards, isn't that right?
Yes, that is true.
And so each time the agency revises any one of the National Ambient Air Quality Standards, it triggers an obligation under the Clean Air Act for the state to develop a SIP, a state implementation plan, addressing those interstate impacts, correct?
Yes, that's true. You know, when Mr. Nguyen was going through his final question, I thought about mentioning that the PM SIP process was definitely a parallel or corollary to exactly the same for the NOx issue that we're talking about.
And in fact, the initial cross-state air pollution rule, I'll refer to it as CASPER, did include an SO2, a sulfur dioxide trading program, in part to address PM non-attainment downwind. Is it under the 2005 PM standard? Is that correct?
I'd have to go back and double check. I don't recall. I mean, there is an SO2 trading program
Yeah,
that
okay.
we work under, yes.
Great. Well, I guess since you brought it up, and before we go into 126, let's talk about a little bit about the other provisions of the or the National Ambient Air Quality Standards that could affect these coal units. Now, you mentioned PM, and I want to come back and touch on that and make that absolutely clear. I think Mr. Kwong, do you happen to have the exhibit that Mr. Kwong used in his examination for you?
Just for clarification, make sure we're talking about the Louisville Metro Air Pollution Control District report.
That's right.
Thank you. Yes.
Yep. And you'll recall, if you turn back to page 2 of that document, there was a line of questioning related to EPA's proposed revision of the PM National Ambient Air Quality Standard. Do you recall that?
Yes.
And so if EPA, just to be clear, if EPA establishes a 10 microgram per cubic meter limit, or standard rather, the Louisville area will be in non-attainment with that standard. Is that correct?
So the reason I'm pausing is I would like to say that the actual attainment to that standard will be based on the following 3 years after it's finalized. So it's possible that Jefferson County could reduce its particulate matter over the next few years and achieve attainment prior to a designation, if I recall the process correctly.
Okay. Thanks for that clarification. Assuming this 2021 to 2023 value is maintained or persists, the area would not be meeting a 10 microgram per cubic meter standard.
Yes, absolutely, and I'm sorry these are complicated things,
No,
But yes, if we continue to maintain that level, we will be considered non-attainment.
and then so 2 follow-ups. We spoke a moment ago that the revision to the PM standard would trigger interstate obligation or pollution obligations for Kentucky, correct?
Yes, yeah, I mean, yes, a state implementation plan, yeah.
And that it would have to
Update.
it would have to ensure that they're not significantly contributing to downwind non-attainment. And if the state doesn't do that, EPA has a statutory obligation to step in with its own plan to make sure that there's no downwind impacts. Is that correct?
Yes, that's correct, directly corollary to the other NOx program, yes, exactly the same.
Great. And so let's pivot then to yet another part of the Clean Air Act that addresses all of these national ambient air quality standards and how to maintain them. We'll talk about local attainment standards, as I think you referred to it as. Is that correct?
Well, I would say local attainment standards are still part of the National Ambient Air Quality Standard. Yes.
Right, and so every state implementation plan that Kentucky comes up with has different elements, and among the many are the one we talked about, the transport rules. And then, of course, the state has to ensure that every area within the state attains or comes back into compliance. Is that correct?
That is correct.
I do want to just make one quick clarification. At page 12 of your rebuttal testimony, at lines 17 through 19, you state that Jefferson, Oldham, Clark, and Floyd in Indiana, and is this Bullitt? Is that how you pronounce that? I apologize.
Yes.
Those areas are in a, quote, EPA attainment area. Is that, do you see that?
Yes.
It's actually a non-attainment area, though. Is that what you mean?
That sentence is, I understand your question. That sentence was not necessarily to address attainment or non-attainment. Those groupings go together with respect to the assessment of attainment. But yeah, they're an area, and that area today is non-attainment.
Great. And so, for non-attainment areas under the Clean Air Act, the state must come up with a plan or regulations that ensure that that comes back into attainment. Is that fair?
The state as well as the Louisville Metro Air Pollution Control District, both, yes.
And again, like the other provisions, the transport provisions, if the state doesn't do it, doesn't put together a plan, EPA has an obligation under the Clean Air Act to step in and do it for them. Isn't that correct?
That is correct, and I would add to it, the same, we should use Louisville Metro Air Pollution Control District and the state synonymously in the context of Jefferson County and Bullitt, Oldham, that area. Yeah.
Okay, thanks for that clarification. So I will use them synonymously rather than trying to distinguish them. And so in particular, again, among many other obligations, the state must impose what's called reasonably available control technology at major sources of pollution that are within a non-attainment area. Is that correct?
That is correct, and I may have mentioned that earlier in testimony, yes.
And so we talked a bit before, Mill Creek 1 and 2 are within the non-attainment area, correct?
Correct.
And so that means that even aside from the Good Neighbor Plan and aside from Casper, there's a separate obligation to meet reasonably available control technology.
That is correct.
Okay? And would you agree that, generally speaking, reasonably available control technology is SCR technology?
Generally speaking, the answer is yes.
Great. I want to clarify one thing that came up maybe the day before yesterday. Somebody mentioned that Mill Creek 1 is already subject to a binding agreement to limit its operations. Do you recall that?
Yes.
That limitation doesn't have any relevance to whether Mill Creek 2 would need controls to comply with RACT, does it?
No, I failed to see a connection between the two constructs.
Let me just make sure I understand your response. So the limitation that exists at Mill Creek 1, its operations, shouldn't affect whether Mill Creek 2 would be subject to an SCR. Is that correct?
That is true.
Okay, thank you. Now, there was another discussion earlier today about whether sources outside the non-attainment area could also be subject to emission reductions to help bring that area into attainment. Do you recall that line of questioning?
Yes, I do.
Now, the Clean Air Act speaks about reasonably available control technology as a minimum for major sources within the non-attainment area. Is that correct?
Correct?
There's also an obligation for the state to impose what are called reasonably available control measures that are necessary to bring the area into attainment. Is that correct?
That is correct.
And within that authority, states do have the ability to impose controls on sources outside the non-attainment area. Would you agree with that?
Yes, I agree with that.
Okay. And so that could mean, for Gen 2, for example, if the state had evidence or indication that Gen 2 was contributing to non-attainment problems in the Louisville area, they too could be subject to emission reductions of NOx.
Yes, that is true, and you put it in a better state than I did this morning.
All right, thank you. And then just to come back to this, are you aware that EPA, in effective November 2022, reclassified the Louisville area to what's called moderate non-attainment?
Sorry, can you repeat that? I think I misheard the wording exactly.
Yeah, well, so let's back up again, because for the ozone program, the Ozone National Ambient Air Quality Standards, there are levels of non-attainment, beginning with marginal non-attainment, is that correct? And proceeding up to increasingly stringent emission reduction levels, is it?
Yes, I'm very familiar. I think I just misheard the way you stated that
Okay.
question.
And so in November of this last year, EPA determined that the Louisville area did not meet the 2015 max and, quote, bumped it up, sort of in the common parlance, to what's called moderate non-attainment. Are you aware of that?
Yes, I'm absolutely aware. I thought I heard you not say the word non in that.
Okay, thanks for clarifying. And so, in response to that reclassification, Kentucky was actually required to submit that plan we've talked about, the state implementation plan, by January of 2023. Are you aware of that?
Yes.
And they failed to submit a plan, didn't they?
Louisville did not submit a plan. That is a true statement.
Okay. And I think we touched on this, just to for clarity. EPA, well, let me back up. In response to Kentucky's failure to submit a plan, EPA issued what's called a finding of failure to submit. Are you aware of that?
For the city of Louisville,
For
or
the-
LMAPCD's actions.
Right.
I recall, but I'll say no for purposes of poor recollection exactly.
Are you aware that under the Clean Air Act, if EPA did indeed issue such a finding, that the federal agency then has an obligation within 2 years to impose its own implementation plan, bring that area into non-attainment, or?
Yeah, yes,
Okay.
I am definitely aware.
Okay, great, thank you. You mentioned, and just to clarify this point again, you mentioned in your rebuttal testimony, a petition to redesignate the Louisville area as being in attainment. Do you recall that part of your testimony?
Yes, I definitely recall it, and that's kind of what was giving me pause on the last line of questioning.
Right.
Yeah.
And because of for the reasons that you went over with Mr. Kwong, because the area is not in attainment, that designation petition cannot be approved.
I
you agree
would
with that?
suggest it's EPA discretion but yes, EPA has not finalized that. Although they published it for public comment, they never finalized the redesignation to attainment because of the data for this year.
Okay, good. So we've walked through, and I don't want to belabor the points, we've walked through the risks under the transport provisions of the ozone National Ambient Air Quality Standards and the risks associated with local attainment and the requirements within the state. Correct?
I agree.
Yep. And so even if the NGCC were denied at Mill Creek 1 and 2, those two units still face, would you agree that those units face significant nitrogen oxide compliance risk going forward from the ozone standard?
Absolutely, yes.
I want to shift gears a little bit to yet another program under the Clean Air Act, the Section 126 of the Clean Air Act, where we kind of left off, and I'm sorry it's taken longer than I intended to do. But you mentioned in your testimony a pending 126 petition from Maryland, New York, and New Jersey. Can you briefly describe what that is?
So, as we discussed a little bit earlier, several states petitioned the EPA to address emissions from upwind states. Upwind, downwind. I get confused when I'm using those terms, but so yeah, those petitions have worked their way through the courts, and I understand the unified agenda, as noted on my rebuttal testimony, has further is the attachment to the rebuttal testimony references those are going to be
Okay. And it,
acted on next spring, if I remember correct, or the fall and spring, fall of this year and the spring of next year.
great. And you're aware, and I believe this is reflected in your rebuttal testimony, but you're aware that the states at issue, New York, New Jersey, Maryland, Connecticut, I believe, allege that emissions specifically from Gent and Mill Creek 1 and 2 are contributing to non-attainment problems in their state.
Yes, the New York, oh, I'm sorry. Yeah, yes, the New York petition, those petitions referenced, I think, there's 350 units across 7 states. Yeah, and Gent and Mill Creek were referenced.
And that petition explicitly asks EPA under 126 to impose emission reductions at those 2 units, among others.
Yes,
And so independent of Good Neighbor Plan and independent of implementation of the 2015 ozone standard within the state, there's this 126 risk. Is that correct?
yes,
And if EPA were to grant that 126 petition, would you agree that they would likely impose SCR technology at Mill Creek 1 and 2 and Gent?
yes. And I will go further to state that the EPA's contention is that the Good Neighbor FIP addresses that already. And so that's the purpose of the Good Neighbor FIP in some way. And like one reason for the FIP is to address these Section 126 petitions.
Yeah. Well, great. So it's kind of like a backstop. Would you agree?
Yeah, and if the FIP, Good Neighbor FIP goes away, those states will be back at the EPA pushing again to get reductions from, back to your point specifically, Gent and Mill Creek.
Okay, great. Thank you. I want to pivot to yet another Clean Air Act program, the Regional Haze Program, which you mentioned in your rebuttal testimony. Is that correct?
Yeah, I referenced it.
It hasn't come up a lot during this hearing, but can you briefly describe what the program requires?
I'm going to be blunt with the regional haze rule. We have not had a lot of activity under the regional haze rule, and the compliance dates historically have been out for quite some time. So it's not a rule that I've paid much attention to or put much research and my time on over the years. But the Mill Creek Station does have best available retrofit technologies for regional haze. So, I mean, it is something that we've been addressed in. It's in our Title V. Its impact going forward, I don't recall exactly.
Okay, well, let me parse that out, and we can talk a little bit more about that. So the Regional Haze Program is designed to protect visibility in certain national parks and wilderness areas, correct?
Yeah, I definitely agree with that, yes.
And one of those is Mammoth Cave, is that right?
Yes, it is.
Which is, would you agree it's kind of an iconic national park?
Yes, I've been there.
Right. And so under the Regional Haze Program, states are required to submit yet another state implementation plan addressing pollution that impacts visibility in those areas like Mammoth Cave. Is that correct?
Yes, that's true.
And generally, the program addresses pollutants like sulfur dioxide, nitrogen oxides, and particulate matter. Is that correct?
Yeah, those are all, yes, I agree with all that.
And as a general matter, the focus has often been on large sources of pollution, like coal plants.
Yes, that is true.
And the states actually had an obligation to submit a plan, a revised state implementation plan in 2021. Is that correct?
Yes, that is correct.
And under those plans, the state is required to establish, evaluate, and to the extent necessary to protect visibility, establish emission limitations at sources that impact visibility to achieve the national goal of bringing visibility back into sort of what's called natural visibility conditions. So that's a lot to unpack. Does that make sense?
Yeah, no, I'm familiar with the construct.
Okay, and so as a general matter, you would also agree that EPA expects states to implement cost-effective pollution controls at sources that impact visibility in those areas. Is that correct?
That is correct.
And so among the kinds of emission reductions EPA and states have deemed cost-effective are, for nitrogen oxides, selective catalytic reduction, like we've been talking about throughout most of this hearing. Is that correct?
It could be brought into the equation, yes.
And for sulfur dioxide, EPA has often looked at what's called flue gas desulfurization as a method to address those impacts, correct?
Yes.
Now, are you aware that EPA has regulations that establish, as a general matter, for nitrogen oxide, as a general matter, that best available retrofit technology would be about, for the kinds of, well, would be about 0.15 pounds per MMBTU NOx at tangentially wall-fired coal units?
I don't recall the limits under BART specifically.
But you're aware that there are regulations specifically addressing these limits?
I'm aware the regulations exist. I don't recall if it's unit specific or if you can comply across multiple units at a site.
Okay.
It's not in my wheelhouse today.
Great. But 0.15 would be pretty close to what SCR technology would be expected, and probably even higher than SCR.
Yeah, it's definitely higher. I mean, as if you recall, under the Good Neighbor Plan, when I walked through the 150 divided by 6 divided by 3, the new SCR requirement is 0.05. So, yeah, it's 3 times what the Good Neighbor Plan thinks of control technology for NOx.
And we discussed earlier how the units at Mill Creek, both 1 and 2, each 1 and 2, and Gent, each emit nitrogen oxide at about 0.3 pounds per MMBTU.
Order of magnitude, yes.
Order of magnitude. Can you explain what you mean by that?
The, the NOx emission rate, it's not linear, so between 0.3, 0.35, I mean, in that order of magnitude, yeah.
Okay. And so if EPA or the state were to decide that emission reductions of NOx were required at Gent or Mill Creek, 1 or 2, they'd probably have to reduce emissions, would you agree, by about half?
I would agree, that's how the math works, yes.
Yep.
Yep.
Thank you. And so, I'm going to just touch on it again. You are aware under this program as well, Kentucky did not timely submit a regional haze state implementation plan. Is that correct?
Yeah, I am.
And are you aware that under this program as well, EPA issued a formal finding that the state failed to submit a plan?
With the state of Kentucky, I do recall that, yes, recently.
And like the NACS provisions, that triggers an obligation for EPA to implement its own plan. Isn't that correct?
Yes.
So, try to put a fine point on it, gone through setting aside the NSR permitting issues at Mill Creek, and then setting aside, independent of Good Neighbor Plan, and independent of Casper, independent of RACT, and independent of 126 under the Clean Air Act. There's another risk associated with nitrogen oxide emissions at these coal units. Is that correct?
With BART, yeah. I mean, you're doing a fine job of conveying that there's belts, suspenders, and other ways that the EPA is unrelentingly addressing emissions from coal-fired power plants. Absolutely, and part of the reason I haven't paid close attention to BART is it's down below these other ones. There's a number of things on top of it. So
Yeah.
yeah, it's a tough place to be in to try and keep coal-fired power plants operating these days.
And so you would expect one way or another, SCR is going to be required at Mill Creek 1 and 2 and Gent.
Yeah, absolutely. I mean, yes.
And for the moment, I want to come back to one idea here that's come up a couple times over the last couple days and ask you about this. There's been some suggestion that Mill Creek 1 and 2 and/or Gent could operate without SCR if they limited operations to non-ozone seasons. Do you recall that line of discussion over the last couple of days?
Yes.
Okay. And that's because the ozone National Ambient Air Quality Standards is concerned with that period of time where you get the highest ozone readings, which is generally the summer. Is that right?
Yes.
Okay. Are you aware that under the HAZE program, the Regional HAZE program, there is no such seasonal limitation? Is that-
Yes, I'm aware of that.
And so under the Regional HAZE program, and in fact, for the purposes of visibility impairment, EPA has found that wintertime NOx emissions sometimes have a greater impact than other parts of the season. You aware of that?
Yes.
Okay. And so, to comply with the Regional HAZE program, you can't just, KULG&E couldn't just get away with operating in the non-ozone season, right?
I don't know that for certain today.
Okay. Okay. Let me switch to sulfur dioxide, which we talked a little bit about under the Regional HAZE program. You mentioned BART at the existing units.
I'm sorry. Yeah, I'm gonna need a reminder of the acronym of BART.
Best achievable reduction technology, I believe.
Close. Best available
Is it best available? Okay. Achievable and available, yeah. Thank you.
Best available retrofit technology.
Right, yeah, retrofit.
Does that sound right, Mr. Ember?
Best retrofit technology for sure, yeah.
Thank you, Mr. Ember.
And this is kind of a point worth just mentioning briefly, just as kind of some context. Congress used that term retrofit technology in part because under the Clean Air Act amendments, existing, the initial amendments in 1977, initially, existing sources were exempt from coming into compliance with certain more stringent standards. Isn't that right?
Yes, it is correct.
And so Congress envisioned, with the best available retrofit technology provisions of the Act, that those old sources would eventually come into compliance with more modern technologies. Is that correct?
Yeah, the Clean Air Act has lots of ways to push retrofits, and, yeah.
And that's why there are all these provisions like, anyway, I'll leave it at that. I'll withdraw that. Let's talk a little bit about SO2, because you mentioned, we talked about that a little bit at the outset under regional haze. Are you aware that the, hold on one second. Are you aware that Gen 2 has an average SO2 emission rate of about 0.36 pounds per MMBTU?
I would have to go back to our operating data to confirm.
Are you, did you happen to read the various interveners' testimonies in this case?
I've read a lot in this case.
Do you recall reading Mr. Lane Collins' testimony?
Sitting here right now, I don't recall specifics.
Is it possible to bring, you don't have it, okay.
Put it up on the screen.
Yeah. Unfortunately, my screen share and my computer are not cooperating.
Yeah, and I'll tell you, Mr. Smith, it doesn't look like right now you're actually signed in. So that's gonna be difficult to share your screen.
Okay.
But the council can provide Mr. Collins' testimony to him if you have a specific question about it.
Before you move on, can you double check the connectivity?
Candace, are we?
Okay. I've gotten a message asking if we were back on, so I just wanted to double check.
One second, Mr. Smith.
We've got it.
I was gonna say, you'll have to tell your person to check their connectivity. Mr. Riggs, can you ensure that Mr. Ember has Mr. Collins' testimony available to him?
Okay. I think we may be able to bring it up.
We'll be able to put it up on the screen, Your Honor.
I can share that. You got that, Mr. Riggs?
Are we able to, there we go. We got it. Thanks for your patience, Your Honors.
And just to make sure we know what we're looking at, can you ask Mr. Gary, can you go back a single page just so we can see just one page? Because I think we all know how Mr. Collin does his attachments. There we go.
Okay. Thank you. So this is Exhibit 3 to
Anthony can hear us, so he'll come out. Give it 1 minute. I think we probably do. Mr. Smith, can I wave? Just wave. It's working. They're green. We've been on, and it only shows me when I make a terrible face, and then otherwise, otherwise it goes black. And it did catch Mr. Smith waving, so that's good. It's on a little bit of a lag. Okay, let's just hope it doesn't go black again. Mr. Smith, would you like to continue your cross-examination?
Yeah, thank you, Your Honor. Mr. Ember, before we took our break, we were talking about SO2 emission rates from Gent 2. Do you recall that?
Yes.
And we were talking about this in the context of the Regional Haze Program again, right?
Yes.
Just backing up one moment, we talked a little bit about NOx emissions under the Haze Program, and then there's also SO2 emissions, which can be which are generally regulated under the rule. Is that correct?
Yes.
And we talked earlier about a presumptive, what's I'll refer to as presumptive limit for nitrogen oxide emissions that EPA has established in its regulations. Do you recall that?
Yes.
And there's a similar presumptive limit for SO2. You aware of that?
I don't recall what it is.
Okay. Would you accept that the regulations say it's 0.15 pounds per MMBTU?
For SO2?
Mhm.
I'll accept that for
Okay.
purposes here.
And are you aware that modern flue gas desulfurization can actually achieve much better limits than that?
Yes, and there are other EPA standards that require less than that.
Okay, right. So they can, modern FGD systems, again, flue gas desulfurization scrubbers, they're sometimes referred to, achieve as low as 0.04, 0.06. Would you accept that?
I'm going to say yes. I've got a lot of things running through my head, so, but
Okay.
yes.
Can we take a look here, and hopefully it'll work on the share screen? This is, again, Mr. Collins' Exhibit 3 to his direct testimony. And if you can see that there, on the bottom line, the bottom row of that document, or first of all, can you identify this document?
No.
No? Do you see up in the left-hand corner there, S&P Capital IQ?
Yes.
Are you familiar with that service, that company?
I don't use it, no.
Are you aware, though, that it's pretty commonly used in the industry?
Again, I'd say no, I'm not familiar.
Okay. Well, I guess that document at the bottom bottom there, the bottom, very bottom and far right row indicates that the Gent Unit 2 achieves an emission rate of about 0.36 pounds per MMBTU for sulfur dioxide. You see that?
Yes.
Your Honor, I object. This is not his document. He doesn't know anything about it. This is Mr. Collins' document, and he's being, the examiner proposed to examine Mr. Emmer on a document he has no personal knowledge of, he doesn't recognize the source, he doesn't use it in his professional capacity.
Well, he hasn't moved to introduce the document yet, so if you have an objection to a specific question, I'm perfectly happy to take it, but until he moves to try to introduce this document, I don't know what the objection is based on.
The objection would be based on, Your Honor, not only as to the admission of this document, which may be admittable once through Mr. Collins, if he's has the knowledge of it, but it's certainly not admittable into the record by Mr. Ember, who knows nothing about it. There's no foundation for that. But more specifically to your question to me, the examination of a witness on a document that the witness didn't prepare, doesn't have any personal knowledge of, and doesn't recognize is the examination of the witness on complete hearsay.
Counsel?
Your Honor, I was intending to use this just to inquire as to whether he was aware of recent emission limits that the unit is achieving. I'll withdraw the line of questioning if that's all right.
Okay. That's fine. That's fine. I will say, just stepping back from this, because this is not in front of us now, but as a general matter for the rest of the hearing, counsel has agreed to withdraw the question, or I wouldn't say this. So,
Right.
but when we have something like this that's directly from EIA data, I think of it similar to the commission's annual reports. There may be 5 people associated with the companies that have ever seen the annual reports. It's very hard to say that Mr. Ember wouldn't be able to answer questions specific to emissions data that's filed with the commission or filed with EIA. And so as a general matter, I'd just say it's probably better for us to get information if Mr. Ember has any personal knowledge. But since you're ready to move on, please continue.
I'll be guided by your direction.
I just want to be clear that we would rather, I'll speak for myself instead of on behalf of the entire commission, but I'd rather get more information and then provide it weight according to the where it came from, as opposed to not having the information in the record available for us to make a decision. But certainly, you're right to make an objection, Mr. Riggs.
Thank you, Mr. Chairman.
Counsel?
Thank you, Your Honor. Well, I guess I do want to just follow up on a comment from the commissioner. You are familiar with EIA data, are you not?
Yeah, I'm familiar with EIA and the data that we submit to, and EIA does publish, yes.
Okay. And I guess I'll just come back to an earlier question. Would you accept that Gen 2, its emission rate is higher than 0.3 pounds per MMBTU?
I would need to look at my operations. I don't know what it is today. I'd like to look at my Title V permit, validate my limits, and look at my operating history to answer a question like that.
Do you think that if EPA or the state required additional emission reductions from Gen 2, SO2 emission reductions from Gen 2, that it could impose additional costs on the operation of that unit?
If additional SO2 reductions were requested from Gent, it would have, at a minimum, operational cost and possibly capital costs as well.
Okay. Let's move on from air regulations and talk a little bit about water and Clean Water Act regulations.
Okay?
All right? And I want to try to just break some of these down as well, because there was a little bit of confusion earlier, or a little bit of, confusion earlier, I'd characterize it as. You talked a little earlier about what was called 316B. Do you recall that discussion?
Yes, I do.
And 316B refers to a section of the Clean Water Act, is that correct?
Yes.
And that section of the Clean Water Act is designed to protect against, protect endangered and threatened species for the most part, sensitive species, is that correct?
I would characterize that as a true statement, kind of, I mean, focused on fish impingement type stuff, yes.
And so to implement that section of the Clean Water Act, EPA issued a regulation that everybody commonly refers to as 316B regulations, correct?
Yes.
And one potential requirement of 316B is a requirement that coal generating EGUs limit their intake of cooling water. Is that correct?
I don't know that I would directly characterize it as limit their intake. But I definitely would say the velocity of the water flow into the intake is definitely what I'm familiar with.
Okay, well, thanks for that clarification. And the 316B regulations look at velocity and for units, for coal units that intake water at 125 million gallons per day or faster, those are the units that are supposed to do this analysis that council was referring to earlier. Is that your understanding?
Yeah, no, yes, I would agree with that.
And for Mill Creek 1 in particular, are you aware that it intakes about 285 million gallons per day for cooling water?
I am aware it takes in a lot. The exact number, I don't recall. I used to put it in our DMRs, but our data monitoring reports for our KPDS permits. But the number, I'll take your word for it at that level.
And you actually provided a responsive data request that has the application, and you can go look at it in the record, is that correct?
Sure, yes. Application of our KPDS permit you're
Yep.
mentioning, yes.
And so that 125 million gallons per day benchmark or threshold is what EPA established as a threshold to evaluate whether best technology should be installed to limit that cooling water intake, or limit the velocity of the intake, is that correct?
That's correct.
And so generally speaking, best technology available for cooling water intake would be the cooling tower that you referred to earlier. Is that correct?
That's true.
Okay. And so to avoid having to go down that potential analysis, the company has in its application committed to retire Unit 1. Is that correct?
I wouldn't say it was to avoid going through that analysis. It was just from a cost and time and work scope perspective. If we had planned to retire something, we'd use the process to exempt rather than do the work. Yeah. So, yes.
Well, you would agree that so the best technology available concept requires the company and the permitting agency to look at a variety of factors, the cost of cooling water intake upgrades, right?
Yes.
And among others, the effectiveness of those structures in avoiding impingement or entrainment. Would you agree with that?
Yes.
And so if a particular unit's intake is more than double EPA's sort of benchmark threshold, you'd expect that you'd have to install some kind of retrofit to address that issue. Isn't that right?
Yes,
Okay.
I think as
And
I
I-
was
and I think-
testified earlier today,
Right, and I
yes.
think, what is the cost of installing a new cooling tower for Unit 1?
I believe that was mentioned earlier by Mr. Beller or Mr. Wilson. I'd rather not give a number off the top of my head. I would defer to them. It was in the 20 million plus dollars, 25 type. I don't remember the name. The record probably should speak for itself.
And so obviously, if Mill Creek stops operating, that risk goes away.
If it stops operating along the time frame where we've committed, then yes.
Thank you. Now, I want to distinguish that from the effluent limitation guidelines, which regulate discharges of polluted water, correct?
Effluent limitation guidelines address discharges, correct?
Now, at the outset, there are currently effective effluent limitation guidelines that affect the companies Mill Creek 1 and 2, and Gent, and E.W. Brown 3. Is that correct?
All of those are impacted by current 2020 ELG rules, yes. Effluent limitation guideline.
And so the most recent permits that the company has and you provided have limitations that are designed to comply with the currently effective regulations. Is that correct?
They have limits and applicability dates for those limits, yes. The permits include that information.
Okay. One aspect of the existing rules requires coal units that discharge what's called bottom ash wastewater to eliminate those discharges by 2025. Is that correct?
Not in totality, no.
There is a little bit of a loophole, right? There's what's called a 10% purge exemption. Is that correct?
That is correct. For bottom ash transport waters, yes.
Right. And another part of the regulation requires limitations on what's called flue gas desulfurization wastewater. Is that correct?
Yes.
And let's back up just a minute for everybody's edification, maybe, if people aren't aware. What is bottom ash wastewater?
Bottom ash is a kind of a glassy type material that is generated at with combustion of coal. It falls out of our boilers to the bottom of the boilers and it gets collected. In some of our units, that glassy material is transported by water to its separation processes.
Okay.
So that the bottom ash transport water would be the motive material to get the water to get the bottom ash to its separation process.
And flue gas desulfurization wastewater, could you briefly describe that?
So as discussed, we burn coal. The flue gas that goes out, for illustrative purposes, the top of the boiler goes through a number of processes, eventually to large vessels that spray water and limestone into to remove sulfur, as well as some other things, but that sulfur turns into gypsum, and the water from that process is transported to separation processes. So the water from the wet FGD system, or the wet flue gas desulfurization system, must be treated per the effluent limitation guidelines, and as we've permitted for our facilities.
And Mill Creek 1 discharges both bottom ash and FGD wastewater, is that correct?
No, that is not correct.
Okay. Will you explain?
Mill Creek 1 has a dry handling system for bottom ash. So at Mill Creek 1 actually only has the FGD wastewater.
Okay, does Mill Creek 2 discharge bottom ash?
The Mill Creek site does not have bottom ash transport water.
Okay. So you've been watching as, I believe, Mr. Wilson and Mr. Villar before him talked about what were called stay open costs at each of the coal units at issue here.
Yes, I have.
Yeah. And in that chart, you'll remember the table, there's a column for stay open ELG costs at Mill Creek 1. Do you recall that?
Yes.
And that column lists several $1 million to continue operating that unit and in order to comply with the ELG rules. Isn't that right?
Yes.
Do any of those costs apply to Mill Creek 2? So let me back up and give you an example. If Mill Creek 1 were, well, I'll back up even further. There is a provision in the ELG, the effluent limitation guidelines, that allows coal burning EGUs to retire rather than comply with those limitations. Isn't that right?
Yes, that's true. It's called the Notice of Planned Participation, also known as a NOP.
Okay. Did the company submit a NOP related to Mill Creek 1?
No.
So, going back to the other unit there at Mill Creek 2, does Mill Creek 2 discharge bottom ash?
The Mill Creek site does not have bottom ash transport water, so Mill Creek 1 nor Mill Creek 2.
Okay. Mill Creek 2, does it discharge FGD wastewater?
Yes.
Okay, so the ELG costs that are required currently for the Mill Creek units for FGD wastewater apply to the facility as a whole, is that right?
Yes, they do.
Okay.
Yes, they do. Sorry.
So if you retire just one, you still gotta invest to address the discharges, right?
So, going back to our 2020 ECR, that environmental cost recovery process, we applied for and are in construction now for a treatment system for wet FGD wastewater that complies with the 2020 ELG revision. And that system was approved and designed for sizing of Mill Creek 3, Mill Creek 4, as well as Mill Creek 2. We did not size it for Mill Creek 1, and it was left out of the ECR for that purpose.
Okay. And you're aware that EPA has proposed revisions to the effluent limitation guidelines, correct?
Yes, I am, and it's a doozy, yes.
Okay, yeah, let's talk about it then. That sounds interesting. So, we discussed Mill Creek does not discharge bottom ash, but the proposed rule has new requirements for flue gas desulfurization wastewater, right?
I will answer absolutely yes, it does.
Okay.
Yes.
And those are over and above what the company's already planning to do there?
I would contend in lieu of, but yes, over and above, sure.
Sorry, Mr. Smith, before we go to the next question, I don't understand the distinction that you just made, Mr.
Well,
Ember.
This is a whole different topic, but nonetheless, the 2020 ELG revision for wet FGD wastewater requires you to go to zero liquid discharge. And although the company is only studying it right now, it appears the equipment, the biological treatment that we're installing today will not be useful in attempting to get to zero liquid discharge. So in lieu of, meaning we're gonna not use the equipment that we're building today and have to implement technology to go to zero liquid discharge, as proposed by December 31st of 2029. So when I say it's a doozy, it's very awkward for us.
Yeah, so just to be, so I have an appreciation, these are this is Project 31 that the commission just gave the companies a CPCN for in like September of 2020.
I would defer to council or a regulatory to answer that
Well,
question.
yeah, I can ask.
I don't
more
know the
direct.
number.
I know, sorry. Again, lack of hobbies on my part. This is the item that you all got the CPCN for at Mill Creek 2, 3, and 4 to comply with ELG.
Yes.
Yeah.
Okay. And so if EPA's new rule, the zero liquid discharge for flue gas desulfurization is finalized as it was proposed, that would impose additional costs at the Mill Creek generating station, wouldn't it?
Yes, it would.
Are you aware of how much EPA has estimated that would cost, or?
I'm aware, we've done some study work related to it, but I'm not prepared to give an estimate. And the EPA range was quite wide as well.
While Mr. Smith does that, you're not prepared to give an estimate on the stand, or like you all don't know the cost, you couldn't give a reasonable estimate, like in response to like a data request.
I think it's well,
Is that-
we have responded in the data request to date that
Yeah.
it is a new rule. We have not performed the engineering and supply chain type analysis to put together a price. We're right now purely in the, even in an engineering strategic perspective, trying to understand how we would attempt to comply to this. So in the timeline of this case, I would contend the company is not prepared to put forth a number.
That's all. I just never know the difference when somebody says, I can't give you an answer, whether you mean you can't give me an answer conceptually, or you can't give me an answer where you're sitting. So that's very helpful. Thank you, Mr. Ambrose.
May I approach, Your Honor?
You may. Would you like to mark this as Sierra Club Exhibit 7?
Yeah.
Okay.
Mr. Amber, you should have in front of you what's been marked as Sierra Club Exhibit SC-7. Now, we talked earlier, and that one of your responsibilities was understanding EPA regulations, is that correct?
Yes.
And as part of that responsibility, I think you said you are familiar with and review periodically EPA's respective dockets, rulemaking dockets that contain technical support documentation and the like. Do you recall that?
Yes.
Do you recognize this document?
No.
Do you recognize the rulemaking at the top as being consistent with EPA's revised effluent limitation guidelines that we've been talking about?
Yes.
Well, let me ask you this. You mentioned earlier that you were aware of EPA's cost estimates for compliance with the new proposal. Have you read the cost estimates that the agency has published?
I have not read the cost estimates the agency has published. I've had staff work with some others in our organization to look at some numbers extrapolated from the EPA numbers, but no, I've not taken time to directly assess this cost estimate the EPA has put forth on the ELG.
Well, two follow-up things, Your Honors. One, I'd like to ask let me ask you one more factual question here, Mr. Ember. You would accept, we talked a little bit about EPA's dockets. You would accept that in the industry, it's common to refer to those dockets to find technical support documents like this one. Is that correct?
Yes.
And you wouldn't dispute that EPA's record is generally accurate. I mean, they've got the documents that they rely on in their docket. Is that correct?
That's a loaded question. But
I-
generally, yes, sure.
Your Honors, I'd first like to ask the Commission to take notice of this document, which I think Mr. Ember has established can be readily determined as being accurate, and there is little reason to doubt the veracity of the document.
Mr. Riggs?
No objection, I guess, question the relevancy of this.
Yeah, I appreciate that. I certainly look forward to your opportunity of briefing the relevancy of it and what way we provide it. But I guess before we even get to your relevance concern, is this the entirety of this document?
It is not, Your Honor, the entirety of the document is like 60 pages or so. So I had printed out an excerpt to use. That I did not circulate it electronically.
Okay. Yeah.
I can do so. I can make the document complete if that's what the Commission would like.
Well, at a minimum, just because I'm sitting here looking and I see that you've included, of course, pages specific to Mill Creek and Gent, but there seems to be at least, to your point, a few dozen pages that are missing for the purposes of having an appreciation for it. So why don't we do this? You're not done with your cross-examination yet, is that correct?
No.
Okay. Could you please circulate to all the council the entirety of the document, and we'll take the, my microphone's been off this whole time, but your motion under consideration until you do so.
Okay, thank you.
And then we'll come back to you, Mr. Riggs, on your objection.
Okay. Mr. Ember, setting aside EPA's specific estimates, you would agree, though, that if the rule is finalized as proposed, it will impose additional costs on the operation of Mill Creek?
Yes.
Okay. I want to ask about one other thing with the new proposal. And now, in addition to the existing limits that we talked about for bottom ash and for flue gas desulfurization wastewater, EPA has proposed limitations for what's called leachate wastewater. Isn't that correct?
I'm trying to make sure I get my terminology right, but yeah, coal residual leachate, I think, is what the term actually is. I don't recall off the top of my head, but yes, in construct, the rule does incorporate others besides wet FGD wastewater and bottom ash transport water.
Okay.
The coal combustion leachate waters, maybe it was.
I believe the terminology is combustion residual leachate wastewater, but
I had all those words in there somehow, but
Yeah.
yeah.
and are you aware that under the proposal, EPA would require what's called biological treatment or chemical precipitation of that leachate.
I am familiar, yes, I am familiar with that.
Okay. And Mill Creek discharges leachate wastewater, doesn't it?
Yes.
And so if EPA finalizes the rule as proposed, that would impose additional costs. Would you agree with that?
Yes, it would.
Now, you mentioned earlier on in the discussion that there is a retirement provision or alternative compliance pathway for retiring these units by 2029 in lieu of compliance. Is that correct?
So my reference previously was under the 2020 ELG revised rule. It was not specific to the 2023 proposed rule, and the notice of planned participation retirement construct is different under the 2023 rule. 2029, I believe, is not the retirement date. I believe it was 2032 in the ELG rule.
Okay. In any event, you would agree, though, that if the Mill Creek units 1 and 2 are retired as the companies proposed in this proceeding, they would avoid all of those additional costs, would they not?
If applied for and approved, they could avoid some compliance costs related to the 2023 proposed effluent limitation guidelines rule.
Okay. I want to shift briefly to the application of these new proposed effluent limitation guidelines to Gent 2.
Okay?
Now, Gent 2 also discharges flue gas desulfurization wastewater, doesn't it?
Yes.
And the new proposal, if finalized, would require zero discharge of flue gas desulfurization wastewater from that unit. Is that correct?
Yes. Yes.
And complying with that provision would presumably impose additional costs on the unit, correct?
Yes.
And now Gent 2 actually also discharges a little bit of bottom ash wastewater, doesn't it?
Yes, the Gent facility does have bottom ash transport water.
And I believe that under the current regulations, the companies applied for and received this 10% purge exemption we talked about a little bit earlier.
That is true.
Okay. But if EPA's 2023 proposal is finalized as proposed, the company would need to eliminate that purge exemption. Is that correct?
That is true.
Okay. And Gen 2 also discharges leachate wastewater, doesn't it?
Yes.
So again, if the rules finalized as proposed, that would impose additional costs at that unit, would it not?
Yes.
But if the company was to retire that unit, you would presumably avoid all of those costs.
The wet FGD wastewater costs, yes. The bottom ash transport water costs, yes. Combustion residual leachate, I've got to think that through further. Off the top of my head, maybe I'm confusing a couple things, but that rule also has landfill wastewaters, or legacy wastewaters. But yeah, it would definitely reduce our costs.
Okay.
I'll just leave it at that. It'll reduce our costs.
Thank you. Shifting to E.W. Brown. E.W. Brown likewise discharges bottom ash wastewater, doesn't it?
No, subject to check, I want to say we went to, no, I'm sorry, yeah, right. Brown does have a 10% purge, yes. So yes, Brown does have a 10% purge.
Okay, great. And as we discussed, though, the newly proposed regulations would require the companies to eliminate that 10% purge.
Yes,
And Brown 3 also discharges leachate wastewater, doesn't it?
yes.
And again, they'd have to, you all would have to either comply with that and eliminate that, not eliminate, but comply with those limitations, which would impose costs. Or you could retire and avoid some of those costs, is that correct?
Again, I'd rather not, leachate, I don't recall exactly how we would address leachate or what our various sources of leachate water would be. So we may have costs regardless of retirement, but I don't recall exactly for the record
Okay.
what our costs would be regarding, which is the whole purpose of why we're studying this stuff now, going back to that statement earlier.
But you'd agree that at least some costs would be avoided by
From-
retiring the unit as you've requested, as the companies have requested in this proceeding.
Some costs specifically related to bottom ash transport water, certainly.
Okay. I kind of want to, before we move on to one last topic, and I appreciate being very patient, I do want to just tie this up a little bit. We've talked about the Good Neighbor Plan, the earlier transport rules, the existing Casper regulations. It's called reasonably available control technology for non-attainment areas. Section 126 of the Clean Air Act, the Regional Haze Rule, effluent limitation guidelines, 316B, and each of those are really independent of each other, isn't that right?
Those programs are all independent of each other.
And so even if the Good Neighbor Plan goes away, there are several additional risks to continuing to operate these 4 coal units for the foreseeable future, isn't that right?
Yes, they're undeniably, the policy coming out of the EPA or the administration is driving environmental regulations that push the end of fossil fuels. Economics is definitely a way of making that happen.
I want to come back now and talk about another Clean Air Act program that is also independent of the others, the 111D proposal. A lot of the conversation that we've had so far in this proceeding has been concerning 111D, but I do want to focus you a little bit on the 111D proposal, if I could. And it might be helpful, Your Honors, if I approach just to provide a demonstrative exhibit. May I?
No.
Mr. Ember, you should have in front of you an exhibit marked as SC-19, or SC-9. Just from the first page, can you identify what this is?
Yeah, this is the May 23rd Federal Register publication of the new source performance standards for greenhouse or gas emissions from new, modified, and reconstructed fossil fuel-fired electric generating units, et cetera.
Now,
It's not the entirety of the document.
yeah, thanks for pointing that out, Your Honors. Once again, in the interest of conserving paper, I printed an excerpt of this just to walk through to, we can or cannot, if you prefer, I can introduce the entire document. It's 180 pages long.
Your Honor, if I may, Joint Intervenors circulated an electronic copy of this document this morning because we were also considering using it as an exhibit, so council should, including staff, should already have a copy.
Mr. Briggs?
No objection.
If it was anything other than the Federal Register, but I don't, yeah. So, just wanna make sure, council, for staff council has a copy of this electronically, is that right?
I sent
its
one this morning.
entirety?
Yes,
So I can peruse all 180 pages.
at your pleasure.
Thank you. Would you like to mark this as SC 9? Mr. Smith, did you, by the way, move for its introduction or just presentation? You have questions about it?
I do have questions about it.
Why don't we start there?
We talked a little bit about this over the last couple of days, but if Mill Creek 1 and 2, Gent 2, and EW 3, or EW Brown 3, rather, are not retired as planned in this, in the company's application, the 111D, D as in dog, proposal could impose significant compliance costs going forward on those units. You agree with that?
I guess the key word in that sentence would be could. Not, it's not necessarily requiring costs,
Okay.
significant costs.
Yeah. Well, let's just walk through this real briefly, because I think it might be helpful for everyone to understand how 111D would operate at the, now 111D under the Clean Air Act operates to, applies to existing stationary sources, is that right?
Yes,
And
and, well, yes, continue, sorry.
well, first I do want to back up and have provide a little bit of context. This morning, when you were testifying, you did distinguish, you recall distinguishing between the Good Neighbor Plan and those provisions of the Clean Air Act and 111B regulations for carbon dioxide. Do you recall providing a distinction between those?
I do recall that dialogue.
And the gist of that, if I may, and if you recall, if your position is differently, please correct me, but my understanding of your answer was the Good Neighbor Plan and the transport provisions of the Clean Air Act are pretty well established, is that right?
Yes,
And so one potential distinction in your view was that regulation of carbon dioxide is not as well established, is that correct?
I agree with that perspective, yes.
And I think one of the points you made earlier was that while transport rules address criteria pollutants, which I think you went over with Mr. Nguyen, correct? 111B and 111D regulations here are related to carbon dioxide, which is not identified as a criteria pollutant. Is that right?
Yes,
Now, but there isn't any doubt, really. Well, let me ask you this. Is 111, the requirement for EPA to regulate carbon dioxide is not going away, is it?
that's a legal opinion that I'm not prepared directly, well, I mean, I'm not sure that I'm prepared to answer that.
Are you familiar with Section 111A of the Clean Air Act? And EPA's so-called endangerment finding?
I'm familiar with it.
And you're aware since you follow these issues, you're aware that the Supreme Court has upheld that endangerment finding, and specifically upheld the finding that carbon dioxide presents a danger to public health and the environment. Is that correct?
I don't recall that exact case, no.
Okay, fair enough. In any case, well, let's shift then to the summary of the proposed 111D regulations. And I don't think we've gone over this anywhere, so let's do it now. So EPA here has proposed essentially 4 different categories of regulation for coal plants, coal EGUs, electric generating units that continue to operate. Is that correct?
Yes.
And so for long-term EGUs, as EPA has categorized them, these are existing units that do not elect to retire by 2040. The proposed rule would require carbon capture and sequestration technology at a 90% capture rate starting in 2030. Is that correct?
You said carbon capture and storage?
Thank you for the
I'm
clarification.
sorry, maybe I missed it. Maybe repeating, please.
Well, let's look at Table 5 on the back page of the document that I circulated, which, sure, you take a look at that. Let me know when you're there and haven't had a chance to take a look.
Can you point me specifically to what you want me to observe?
Table 5 on the back page of the document that I circulated. This would be on Federal Register page, volume 88 FR, Federal Register 33359.
Okay,
And in particular, Table 5,
yes,
captioned Summary of Proposed BSER. This is best, that means best summary, best system of emission reduction. Is that correct?
that is correct.
And so under the first sort of row there, you see long-term existing coal-fired steam generating units. You see that?
Yes,
And 2 columns over under BSER, you see CCS with 90% capture of CO2. CCS means carbon capture sequestration. Is that correct?
I agree with all of that, yes.
And so if any of these units operate past, or don't operate, or past what ends up being 2034, starting in 2030, they will need to capture 90% of the CO2 they emit. Is that correct? Is that your understanding?
I don't want to be difficult, but I will say, yes, with the caveat that the BSER is an actual emissions rate, and if a unit can comply with that emission rate in some other manner, they don't necessarily have to implement the technology. And I will add to that, for more complexity, I apologize. If a model trading program does come to fruition, again, you could comply with trading versus the technology. I'm happy to talk about those further, but for simplicity, 90% carbon capture and storage would be the requirement come 2030.
And so, well, let's just talk about that. If the company wanted to operate these 4 coal units, and when I refer to these 4 coal units, you understand that there'd be Mill Creek 1, 2, Gent 2, and Brown 3. Is that right?
Yes, I understand.
For any of those units that it wants to operate to 2040 or beyond, it's either going to have to install CCS or reduce emissions by 90%. Is that right?
As of January 1, 2030, correct, yes.
Okay, exactly. Thank you. And if you operate any of these coal units to emit only 10% of current emissions, you would necessarily be operating them at a very low capacity factor, would you not?
Yes, pick a month kind of thing, right?
Right, so maybe a matter of weeks out of the year. So that would be a matter of weeks that you wouldn't be able to sell energy, you wouldn't be able to make any energy revenue off operating the units, right? Yeah.
Correct.
Okay. So, I don't want to belabor the point, I just want to go through the other categories very quickly. If you're familiar with them, that'd be great. But there is a medium-term subcategory, and these are for units that commit to retire before 2040, but will operate past 2034. Is that correct?
Is it? Well, yeah, if past 2034 means January 1, 2035, yes.
Okay. And so for those units, EPA is anticipating co-firing with 40% natural gas or achieving a 16% emission reduction. Is that right?
Yes.
So again, if you opted for that 16% emission reduction route, that means you're lowering the capacity factor, the amount of time that you can operate the unit, right?
Yes.
Okay. There's also what's called a near-term category. And these are for units that will operate sort of that interim period of time. Having those units that are going to operate till 2034, end of 2034. And those units would have to take a 20% capacity factor limitation. Is that correct?
Yes.
And then, of course, there's this imminent term subcategory, those units that are going to retire by, oh, so real quick on that 20% capacity factor, that would kick in, EPA is anticipating in 2030. Is that right?
January 1, 2030.
And so that means for those 5 years or whatever, these units can only operate at 20% of their capacity factor. Is that right?
Annually.
Anyway, okay. And then for imminent term, you know, those units that commit to retire by 2032 would have to just maintain their current CO2 emissions without any backsliding. Is that a fair characterization?
Yes.
So I want to come back to the possibility of retrofitting Mill Creek 2, Gent 2 with SCR, as the company modeled and others have suggested. And how that would work with the proposed 111D standard. Does that, you understand where I'm going with that? Sort of. Well, let me put a finer point on it. I'll withdraw the question. So let's come back to the SCR idea. The SCR installation at those two units would have significant upfront capital costs, isn't that right?
They would have significant capital costs.
Yeah. And so I think the company has estimated $100 million for Mill Creek 2. Is that correct?
Order of magnitude, I don't recall the exact number. I defer to Mr. Wilson.
And about $126 million for Gent 2. Does that sound right?
Same.
Now, the companies did evaluate the economics of retrofitting Gent 2, at least, with SCR. You familiar with that?
Yes.
And I believe Mr. Wilson talked about this pretty extensively in his testimony, or at least it's in his analysis in SAW-1. Are you familiar with that?
I'm aware of it.
Yeah. And so you're aware that the modeling indicates that if you install an SCR at Gen 2, it doesn't break even until 2049. Are you aware of that?
I did not study the break-even points, no.
And just so we're on the same page, break even is kind of colloquially, I can't say that word, commonly used to identify that point in time at which the investment pays for itself. Is that a fair statement?
I understand the term, yes.
Okay. So, Mr. Wilson's analysis indicates that with the installation of SCR at Gen 2, that doesn't pay for itself until 2049. Isn't it correct that that analysis doesn't include any kind of CO2 constraint?
I would have to defer to Mr. Wilson as to the various analyses. I know we had carbon costs and models. The very specific number, I don't know.
Okay, but you would, if we go, let's assume that, let's assume that as a hypothetical, that it would not break even until 2049. Will you assume that for the moment?
Yeah, certainly.
Okay. Now, if we go back to the 111D proposal, if you were to burn coal at that unit until through the break-even point, 2049, you would have to meet that long-term limit, either install CCS or limit emissions by 90%. Is that right?
I would agree with that construct, yes.
Now, the company ran, so those are going to be, that's going to be a limitation over and above all the other environmental regulations we talked about. You'd agree with that, right? Are you aware that the company ran an analysis, or what it's called a stress test, to evaluate the implications of 111D and 111B on its selected or tested portfolios, rather?
Yes, I'm aware.
And did you have input into that process? That stress testing process?
I talked about environmental regulation as it goes into the modeling.
Well, I guess in particular, you recall Mr. Wilson going through what was, I think, PSC, response to PSC 5-2. And there's a stress test that includes 4 or 3 different price adders for CO2. Do you recall that discussion?
Yes, I do.
And Mr. Wilson's testimony was, I'm paraphrasing, that those price adders were a reasonable proxy for what the implications of CCS might be on the coal units, and including the implications of the 45Q tax credit. Is that correct? Recall that?
I recall the conversations, but the specifics I can't necessarily testify to.
Okay. Well, I guess what I'm trying to figure out is what kind of input you had into whether that was a reasonable proxy assumption. Did Mr. Wilson and his team confer with you about the costs of CCS and how to develop that price assumption?
The cost of CCS, no. I was not involved in defining costs of CCS.
Okay. Are you aware that under that stress test that Mr. Wilson ran, under every scenario where CCS imposes an additional cost above $0 per ton, retrofitting the coal units or continuing to operate them would be uneconomic relative to the company's preferred portfolio?
Yes, I'm familiar with that output.
So let me come back to the cost. Has the company done any cost analysis or evaluation of what CCS costs might be?
So I would defer to Mr. Sinclair to talk about costs of CCS.
Have you, we talked a little bit about your role in reviewing EPA regulations and reviewing the docket and the like that has technical support documentation for proposals. Do you recall that?
Yes.
Have you reviewed EPA's cost methodology or cost estimates for CCS under the proposed 111D standard?
I have not carefully reviewed them.
Give me one moment, Your Honor.
Yeah, how about we just, I know we've taken a couple of we've had technology issues that have caused us to take breaks, but I think this may be a good opportunity to take a short 15-minute recess and give you an opportunity to get ready for your next line. So
Thank you, Your Honor.
we'll be in recess until 2:55.
Hard stops till 5.
5 o'clock. back on the record, case number 2022-00402. Two things. First is that we will adjourn today, today, sometime between 4:50 and 5 o'clock. We will resume, because I know we won't get done, we will resume the hearing Monday at 9 a.m. here. I want to make sure that I have an appreciation. Sure, Mr. Gardner, okay, Mr. Howard, great. That everybody's here. Is there anything that council's aware of now that would preclude their ability to participate in this hearing late, past the time we've been, normally ending, 9, 10 o'clock, something like that, on Monday evening?
No, Your Honor.
All right, so, let's plan to do so. That way, we're also not here until late on Tuesday night. All right, Mr.
Is
Smith?
still your intention or your objective to conclude the hearing Tuesday?
I'd love to finish Monday.
Sure.
I'd love to get it done this afternoon. The earlier the better. And if we can get it done on a full day as opposed to coming back the next morning to do something every day, I think that should be the goal.
Thank you.
Yep. Mr. Smith, continue your cross-examination.
Thank you, Your Honor. Good afternoon, again, Mr. Imber. I want to just come back to one thought before we move on. Before the break, we talked a little bit about the, quote, break-even date that Mr. Wilson's analysis shows for SCR investment at Gen 2. You recall that?
Yes.
And you're accepting for now that analysis says what it says, or it says 2049, correct?
I like Mr. Wilson's analysis, yep.
Okay, great. There has been a suggestion, the current depreciation life or depreciation schedule for Gen 2 is to 2035. Is that correct?
I want to say 2034, but it could be 2035.
Okay.
I don't.
And so if you installed SCR at Gen 2 and retired the unit at the current depreciation date, that'd be about 7 years, right? By the time you get it installed.
Approximately?
In general, the assumption is that those kinds of investments have at least a 15-year life. Would you accept that?
Certainly, at least.
And so if you operated SCR at that unit for only half of its useful life, there's going to be a stranded cost at the end of that needs to be recovered, isn't there?
I'll agree conceptually, but leave the financing to others.
Okay. And if you did install SCR and operate to 2035 under 111D, we'd actually fall into that intermediate category where you have to either take a 20% capacity factor on the unit, or, well, you'd have to take 20% capacity factor on the unit. Isn't that right? After 2030, I'm sorry.
Yeah, in the construct where there's no model trading program, correct.
Okay. And so if you have
Which
a
there is no model trading program now, so.
And so if you have a 2040, or you have a 20% capacity factor on the unit, maybe it stands to reason you're not going to be making as much money, or the company's revenues are going to take a hit on the operation of that unit. Is that right?
In the construct of less hours operating, less opportunity for revenues, I agree with that that statement.
And so just to be clear too, if the company opted not to install SCR and just continue running it in the non-ozone season, 111D still presents a significant risk for it after 2030, isn't that right?
It would be applicable to 111D, yes.
Yeah. And so the same thing you'd agree would apply to the Mill Creek units as well, right?
Yes.
And the indefinite operation of Brown 3 on coal as well, right?
Yes.
Okay. I do want to come back to the stress test that I mentioned earlier, because now I think I can pull it up. If, Joaquin, can you pull up the Sierra Club? I have the Sierra Club included. Okay. Mr. Ember, can you see this document? Can you read it?
Yes, I can see it and read it.
You see up in so this is, it says table 2 there, PVRR delta from best. How should I identify this? Your Honor, this is the response to PSC 5.2 that we discussed yesterday for your identification purposes. Have you seen this document, Mr. Ember?
Yeah, I've seen it, yes.
Okay. And would you accept this as the analysis that Mr. Wilson ran to stress test the operation of the NGCCs, proposed NGCCs, and 111D against the company's various proposal or portfolios?
Yes.
Okay. And we talked a little bit about before the break that Mr. Wilson and his team thought that the CO2 price adders that the company had, already developed were reasonable price adders because of the way that Section 45Q tax credits might operate. Are you familiar with 45Q?
I am not really familiar with, I mean, I know what it is, but the ins and outs of it, no, I'm not familiar.
Are you aware that the 45Q provisions, which were part of the Inflation Reduction Act, basically provide for an $85 per ton of CO2 captured and sequestered?
Yeah, I'm aware of it, and I know there are lots of stipulations to it that go along. It's a very tricky route, or
Yeah, I can.
to follow, to make sure you're compliant with it. But yeah, I'm familiar with it.
And then, so is this, let me ask you if this is your understanding of the way this analysis was done, is that CO2 price of zero adder, the company essentially assumes that 45Q tax credit basically pays for whatever the cost per ton for CCS would be at the coal units. Is that fair?
I did not do this analysis.
Okay.
I defer to Mr. Wilson into the analysis of this.
Do you have, we talked a little bit about, before the break, reviewing some of the documentation in EPA's 111D docket about costs. Do you recall that?
Can I get more clarification?
Have you reviewed anything in the EPA 111D rulemaking docket relating to the agency's estimated costs for installing and operating CCS?
No, I did not study costs related to CCS very closely in the docket. I'm aware of it, but didn't study it.
Okay, you're aware of it. So I have Your Honors, I have a document that we're up on the share screen. I want to just draw Mr. Ember's attention to it, if I could. Mr. Ember, you said you're aware of the cost estimates the EPA that included in the docket, although you didn't study them. But can I just ask you, Can you see at the top of this document, do you see a file name for this document?
No, I cannot.
It'll have to be minimized in order to see the file name. It's a function of the, or not really, just made smaller, I guess. There we go.
Do you see that file name at the top there?
Yes.
Is that the same?
Sorry, 1 second. Can I ask our IT to put it on everyone as opposed to hidden? Now go back to hidden, please. Can you go back to hidden, please? You have to make the document smaller, like the minimum, not minimize, but there we go.
Mr. Imber, can you read that number, that file name across the top there?
EPA-HQ-OAR-2023-0072-0061_attachment_3 (1)
And so I want you to go back, if you don't mind, and look at that paper copy of the excerpt I gave you as SC-9. You'd agree that that file name is the same as the file name for the 111D rule we had walked through, is that correct?
It is the same, name.
And this is, you're familiar with, this is EPA's convention for identifying different rulemaking dockets, is that correct? It uses this same basic convention in all of its dockets, is that right?
That is true.
And so would you accept that this spreadsheet comes from the rulemaking docket for the 111D proposal?
Yes, I'll accept it,
Okay,
yes.
And have you seen this document before?
No, I have not.
Do you know if there'd be somebody at the companies that is familiar with this document and would be able to speak to it?
No, I'm not aware of anybody that would have dug into the docket to this document specifically.
And as we discussed earlier, generally speaking, you would agree that it's common practice, or you're familiar with EPA's docketing system, right?
Yes,
You'd expect the docket to include documents that are supporting the rule, would you not?
dozens.
And it's generally, one would be able to go to EPA's website and find these documents readily, would they not?
Yes.
Your Honor, I would like I would offer this and ask the commission to take judicial notice of the document. I did circulate this with commission staff and all of the other counsel in the case earlier today.
Mr. Riggs?
No objection.
As notice of it as opposed to introduction, is that right, Mr. Smith? Just so we're clear. All right, thank you. So great.
Mr. Ember, I think you mentioned earlier that Mr. Sinclair might have some cost information about 111D compliance for the coal units in this case. Is that correct?
Yes, I would defer cost generally to Mr. Sinclair.
Okay. Thank you. I guess I just want to come back to a couple more things here. The company's assumption in that stress test, as we walked through, we talked about was that, yeah, the $85 credit under Section 45Q would essentially cover the cost of compliance under sort of a $0 assumption. Is that right?
Yes.
Do you have any opinion about whether $85 per ton is a reasonable cost estimate, per ton CO2 removed is a reasonable cost estimate for CCS technology?
No, I do not.
Well, let me ask you then, okay, fair enough. When you do install CCS technology, are you familiar, are you aware that CCS technology generally requires very high SO2 emission removal, or SO2 removal?
Yes, I'm very familiar with that.
And that's essentially required in order to make the system function correctly. Is that right?
Well, SO2 tends to, well, I'll just say yes. Yes, function properly.
And are you aware that EPA estimates that you would need about 98% SO2 removal to make CCS technology function properly?
Yes.
And so, would you agree that if you tried to install CCS at any of the existing units we're talking about, they would have to achieve that 98% reduction? Is that correct?
To minimize cost and waste and pollutant of your reagents or solutions in the carbon capture system, yes.
And we talk a little bit about Gent in particular, its SO2 removal, its emission rate. You would agree that its current emission rate is probably lower than 98% removal efficiency, wouldn't you?
I don't know the absolute value of it. I do know Gent 2, which I think you're talking about specifically, has the oldest technology for SO2 capture, and has it probably is one of the lower SO2 removal efficiencies in the fleet for sure. Yes.
Okay. So if you're going to add CCS to any of the coal units, you really have to have a modern flue gas desulfurization system. Would you agree with that?
Modern or better.
Modern or better. And so that's presumably going to impose additional costs on operating those units. Is that right?
Yes.
Are you aware that the operation of CCS also increases water usage, cooling water usage for a facility?
Yes.
So that additional cooling water usage would impose additional operations and maintenance costs at any coal plant with CCS, would it not?
Yes.
The installation of CCS at any coal unit is also going to have a parasitic load impact, isn't it?
Significantly, yes.
And there's estimates that it would require a D-rate of coal units in particular by as much as a third. Are you familiar with that?
Yes, I am, and I'm assuming here we're speaking on what is perceived as the potential technologies that exist today.
So any one of the units that we've been talking about that the company proposes to retire, if you had to install CCS, you're going to take a D-rate, meaning it only is able to produce 66% of the power, or generation energy rather, that it otherwise would be able to produce.
I will agree with the D rate. I will leave the absolute value of that number to Mr. Sinclair or Mr. Wilson at this point.
Thanks. And then last on this point, the installation of CCS at any coal unit is going to take up a fair bit of space, physical space at the facility, isn't that correct?
There is quite a bit of equipment, large volume equipment, so yes, it will take up a significant footprint if available on the sites. I've not studied that directly.
So there's a lot of complicating factors and costs involved, is that right?
I would go, I mean, simply yes, yes.
And so, to kind of wrap all of this up, and I don't mean to belabor the point, but we've talked about the good neighbor plan, the cross-state air pollution rule, 126 of the Clean Air Act, the regional haze rule, the effluent limitation guidelines, 316B under the Clean Water Act, and 111D. And each of these, you would accept, I think, that each of these present distinct and independent cost risks for the operation of these coal units. Is that right?
Yes, going forward, yes.
And so to avoid any of those independent costs, the company or challengers to each of any of these rules, they basically have to win across the board. They'd have to win all the way across to avoid all of those costs. Isn't that right?
I guess I'm not following your question exactly.
So
Can you
to avoid
repeat?
each set of costs, I mean, to avoid, well, let's back up to the framing that we talked about at the very beginning of our discussion today. And I think I showed you Mr. Wilson's exhibit evaluating the economics going forward of the different portfolios. And I think you would agree, Mr. Wilson's analysis shows that the company's preferred portfolio is the least cost option in all but one scenario going forward. Is that right?
Yes,
And you also would agree that directionally speaking, that if any one of these independent rules imposed additional costs at the coal units, that would only make the difference larger. It will only make continuing to operate the units appear more expensive than shutting them down, wouldn't it?
yes.
And so, unless somebody comes out and knocks out every one of these regulations, operating the coal units going forward is more expensive than retiring all of them, isn't it?
Yes, under that yes.
Yeah, thank you. And so, we heard from one of the other council earlier this morning about the possibility that some of these might go away. Do you recall that, the possibility that you might not have to have 316B regulation, for example? Do you recall that discussion?
Oh, yes, yes.
Yeah. And so, would you agree, though, with, I think it's Mr. Sinclair's observation that hope is not a strategy for maintaining system reliability? Do you agree with that?
I definitely agree with that statement, yes.
And would you then also agree that hope is not a strategy for environmental compliance with these 4 coal units?
Yeah, no, hope is not a strategy for environmental compliance. That's a,
Thanks, Mr. Ember, that's all I have, Your Honor.
Have, correct me if I'm wrong, but I didn't have Mr. Smith, that you moved to introduce the Federal Register, am I incorrect?
I believe Mr. Smar circulated the full document, and that if the commission is willing, I would move to admit the full document.
Mr. Riggs?
No objection.
And that does remind me, Your Honor, coming back to the cost estimate for the effluent limitation guidelines we discussed, I did at the break circulate with all the attorneys and commission staff the full document there. I don't have it in front of me anymore.
That was the one you asked us to take notice of, correct?
Yeah.
Thank you. And I believe I ruled, gonna take notice of that. And then just to make sure my notes are correct here, I did deny the motion on the EPA memorandum. Right, it's not. That was your understanding as well?
You denied the motion to take judicial notice of the memorandum?
No, you didn't ask for the memorandum. My understanding was you asked for that. You're saying, I'm sorry, take a step back. I thought you were talking about the Excel spreadsheet that we took notice of.
I'm sorry, maybe I'm,
Yep.
I'll try.
Let me tell you what I have
Okay.
record of me doing.
I think you said you withdrew.
I have that you moved to introduce, and I granted SC 6, AGDR 1-1.
Okay.
That you moved, and I don't think I ruled on it yet, you moved to introduce the EPA memorandum, and Mr. Riggs had objected. Is that not what happened?
I did withdraw the request, the offer to admit,
Okay.
but I would request that the commission take notice of the full document.
Of SC 7?
Correct.
Okay, we'll take that up in a second. And then you asked to move to introduce SC 9, which Mr. Riggs did not object to, and then I granted, correct? And we have an Excel document, Mr. Garcia presented, correct?
Correct.
You also asked us to take notice of that, which I have granted. So taking a step back and coming back to the EPA memorandum, you would like the commission to take notice of that document, of the entirety of the, you said it was something like 60 pages, is that right?
I believe it's 68.
Okay. You'd like to take notice of this memorandum, though I don't know, okay. Mr. Riggs, do you have a position on the memorandum?
If it's to take notice, there's no objection.
How about any of the other parties? Okay. My final request, the entirety of the document, when you gave it to commission staff and all the other parties, did you do so directly from the source? Is there a link that we can go to? See, the thing with the Federal Register is, I can find it, right? I see the file name for the other document. If I could ensure that we have the source documentation for the EPA memorandum, and you can provide that in the record, maybe in a notice of filing over the weekend or on Monday, then I can take that up first thing Monday morning. How about that?
Yep.
Any parties have objections to that course? That'll be the first thing we do Monday morning, Mr. Smith.
Your Honor, may I offer a little bit of clarification, or just logistically for your benefits?
Please.
I will not be personally present on Monday morning. Our local counsel, though, will, and so,
That'll be fine.
thank you.
As long as the filing gets made
Yeah, yeah.
between now and then.
It
All
will,
right.
it will. Thank you, Your Honor.
Just a notice of filing with a representation of the source. Thank you. All right. Is there anything else, Mr. Smith?
No, they're not. There's not. Thank you, Your Honors.
Mr. Smar?
Yes, Your Honor, thank you. Good afternoon, Mr. Imber. How are you doing? You hanging in there?
It's a long day.
Well, I will let you know that over the course of your time on the stand, I came in with a lot of questions. I crossed off a lot of questions. I'm going to try to just hit a few things and pick up a few points that make sure they're clear for the record. I'd like to start with, you may recall, I think this morning, I believe it was the commission asked a question about whether you were aware of information as to whether the Gent plant is a contributing source to non-attainment of the 8-hour ozone standard in the Louisville area. Do you remember that?
Yes.
And I think you said that you had seen some information that indicated it might be, but that you didn't have a definitive
Yeah.
position on that. Is that right?
I do not have a definitive, yeah.
Have the companies ever done any air dispersion modeling to try to answer that question?
For NOx at Gent, no.
And I believe that's the process that, when it comes time to determine which sources must reduce their NOx in order to address a non-attainment situation, the relevant agencies would need to do air dispersion modeling. Is that right?
Yes.
I believe that's called source apportionment modeling. Is that right?
Yes.
And in terms of who actually makes the submittal, is it true that it's the Commonwealth that formally makes the submittal, not the Louisville Metro Air District with respect to the Louisville attainment area?
I believe the actual submittal to the EPA goes through the Commonwealth, I believe.
And the Louisville non-attainment area is broader than the jurisdiction of the Louisville Metro, right?
The answer is yes.
I believe there was some testimony on that earlier today. It includes, within Kentucky, it includes Bullitt and Oldham counties, is that right?
Yes.
And it also includes parts of Indiana.
Yes.
And because the SIP submittal to EPA is submitted by the Commonwealth, that submittal looks at sources.
Plays in with the development of it versus the Division for Air Quality. Yeah, I'm not 100% certain.
But the SIP obligation rests with the state, not with Louisville Metro ultimately, correct?
Yes, the SIP obligation belongs with the state.
Move on to another subject. You recall your discussion with Mr. Smith about the effluent limitation guidelines and the proposed supplemental rule that EPA released earlier this year?
Yes?
Mr. Gary, would you mind putting up the second of the two exhibits? Yeah. We'll be sharing a document, just wanted to call your attention to. And this was, Your Honors, I circulated this by email this afternoon to all parties and staff. Do you recognize this document, Mr. Imber? Did you see it up on the screen?
Yes.
What is it?
It is the March 29th, 2023 Federal Register for the effluent limitation guidelines and standards for the steam electric power generating point source category, initial notification date extension.
Do you know what this is?
So the summary here says it is the Environmental Protection Agency's taking direct final action to extend the date for existing coal-fired power plants to submit a notice of planned participation or not for the permanent cessation of coal combustion subcategory in the 2020 electric reconsideration rule.
Is this something you've reviewed before?
I skimmed this, but I skimmed it.
Could you, do you know what it does, what this action purports to do from EPA?
My recollection is it allows folks an opportunity to extend their retirement requests by not complying to the 2020 ELG. The reason I didn't study this further is by the time this came out, LG&E and Kentucky Utilities had already applied for and received KPDES permits to comply with this rule. So this is not effective to me with the operation of our facility. So I did not spend my time studying it.
Are you aware of whether this action would also apply to the doozy of a proposed rule if it becomes finalized?
I don't recall necessarily, no, I don't recall.
So you're not aware of whether this would allow the companies, if the proposed rule is finalized, to opt into that 2028 retirement compliance pathway to avoid the requirements of the 2023 proposed rule?
Now that you say it in that manner, I recall, but again, that was, yeah, I'll just say yes.
Yes to what?
I recall the retirement tie for existing facilities to the 2023, bumping into 2028. There was the original proposal, I think the retirement timeline was for 2032. But actually, I'm probably mixing things up right this second. I'm going to back up.
Okay.
I don't recall this being tied to the 2023 proposed compliance schedule. But if it is, I'll need more education. I recall this being directly applicable to the 2020 rule itself. But again, I don't recall exactly.
Your Honors, in the interest of time, we'd request that the Commission just take notice of this Federal Register document. The document says what it says, and we can address its implications in briefing.
Mr. Riggs,
No objection.
any other party? Okay. We will take notice of it.
How should we mark it, Your Honor?
Yeah, I'll ask you a question. I would ask that you, make a notice of filing, at the end of the hearing, with the document attached to it and the source, the date of the, well, I guess the date of the publication, if Mr. Gary can go down, the date of the publication is listed on the register itself, right on the page?
Yes.
Top of the page, yeah, that'll be fine. If you will attach it as a notice of filing, and just submit that this is the document that we decided to take notice of, that way it's in the record for the benefit of briefing.
Okay, thank you, Your Honor.
Thank you.
You take the exhibit down, Mr. Gary, thank you. One other question about the proposed supplemental ELG rule. So I guess a couple questions. I believe you said earlier that the companies had not developed a cost estimate for compliance with that rule if it were finalized as proposed at Mill Creek, Gent, or E.W. Brown. Is that right?
Yeah, that rule was just proposed in the last few months, so we have not generated cost estimates to the 2023 reconsideration for the effluent limitation guidelines, specific to wet FGD wastewater, bottom ash transport water, coal, residual leachate, and legacy waters.
Would you be able to offer any sort of opinion on that in terms of, like, are we talking, like, a ballpark? Are we talking millions of dollars, tens of millions of dollars?
I'm not prepared to offer a dollar figure. It is not small. That's.
And how would you, what does not small mean to you?
And I think frankly, we're getting to the point of mental and physical limits of this witness.
I'm just asking him to clarify his last answer, Your Honor.
Overruled. Please clarify. You've used a number of terms that are relative, so it would be helpful to understand.
So, can you specifically state units that we're talking about?
Sure, if you want to break it down that way, whatever's easiest for you to explain your last answer.
Unit specifics, I mean, it's tens of millions of dollars, whether it crosses the $100 million threshold on a unit perspective, I don't know. I don't know.
And that's tens of millions per
Per
plant?
unit. Per plant.
Okay, thank you. It's been a lot of discussion today about the netting analysis that you all did as part of the air permit applications that are in the record, right?
I'm sorry, what was the question?
There's been a lot of discussion today about the netting analysis that you did with regard to the air permit applications that are in the record, right?
Yes.
And just to make sure it's clear for the record, that netting analysis involves more pollutants than just NOx, right?
Yes.
That involves a range of pollutants, including VOCs, particulate matter, sulfur dioxide, carbon monoxide, lead, and lead. Is that right?
The criteria pollutants, yes.
And the purpose of this netting analysis is to determine whether there's a net significant emissions increase at either Mill Creek or Brown with respect to the proposed changes at the site, right?
Yes, that's true. Including hazardous air pollutants, but yes.
And the reason why the companies were able to net out of being treated as major modifications in those permit applications is because of assumptions about emission reductions from the proposed retirements at Mill Creek Units 1 and 2 and Brown 3, correct?
Yes, assumptions of the retirement, yes. I mean, those assumptions would have to be permanent and enforceable.
So I think you talked with Mr. Smith in detail about the implications for a major modification with respect to the coal units at those sites, but I'm wondering if there's anything else you can offer as to what would be the implications of having to go through the process of major modification at those sites. What would be the implications for the NGCC units? What additional requirements would they have to comply with if these permit applications were treated as major modifications?
So we would have to do best available control technology evaluations for each of those two units. I would contend that those units are already being procured with best available control technologies. So from a equipment perspective, I don't know that there would be a difference. From a emissions limits standpoint within the permit, if we were to go through a full PSD, potential for significant deterioration permit, I would expect we would have different emissions limits and more emissions limits in our permit than as proposed under the netting process. To go under the PSD, we would also have to do area modeling, emissions modeling, to assess attainment impacts to the National Ambient Air Quality Standards.
Are you able to offer an opinion today about the specifics of what those permits might look like if they were, if the permitting were done in that manner?
I'm not certain I understand exactly what you're asking.
We mentioned potentially more stringent emission limits, right?
Yeah, but for those various pollutants that you mentioned, including some HAPs, we may end up with more continuous emissions monitoring requirements, emission rate requirements that we would have to report on a regular basis than we would under the PSD process as we're netting out.
And that would also include additional air modeling demonstrations to demonstrate that the NGCCs were not contributing to non-attainment of air quality standards, is that right?
Well, that would be a precursor to the actual permit itself. The permit would not contain air modeling type requirements of it.
Part of the
itself.
application
Yeah,
process.
the application process would be different, yes.
Well, rather than dig any deeper into this at the moment, would you be able to respond in further detail in a post-hearing data request on this point? In terms of the specifics of what would be required from the NGCCs if they were to go through a major source permitting analysis?
Boy,
I object to that request. I don't see it's relevant. It's asking the witness to speculate right now.
All I asked was that if he could respond in a post-hearing data request.
And I'll take up the response to the post-hearing data request, but I don't see that it's seeking relevant or likely to seek relevant information.
Take up that objection if you'd like. When you received the data request, is that what your response was, Mr. Briggs?
Yes, sir.
All right, thank you.
Thank you, Your Honor.
I will note that's a lot of work, but
It's a lot of work in terms of, it's an extensive process to go through.
to go through a full PSD and evaluate the emissions, it's a huge amount of work. And that's why I'm pausing with respect to performing that under a data request for something that doesn't seem very feasible, but, sorry.
I'm sorry, doesn't seem very feasible. Why is that?
There's just, with respect to the options in the case right now, has been proposed, that's,
Well, just to lay a bit of further foundation, since there's been a question as to the relevance of this line of questioning, there are proposals on the table that at either Mill Creek or Brown or both, some of the coal units continue to operate, correct?
there's a question on the table about whether or not those units could continue to operate.
Yes.
It's been discussed in the hearing, yes.
The companies have requested approval for their retirement. One of the issues the commission has to decide is whether to approve those retirements, correct?
Yes, under the Senate Bill 4 requirements, yes.
And so if those retirements are not approved, there's been discussion in this hearing about the permitting implications of that, correct?
If the retirements are not approved, then the permitting activities don't become relevant on the units we proposed.
And so questions concerning what were to happen if the NGCCs were permitted as major sources under the Clean Air Act are relevant to this proceeding, correct?
Objection, Your Honor, that's not the company's position.
I'll try to re-ask the question. I believe that you testified earlier that Well, I'll withdraw this line of questioning. We can take it up post-hearing. I think I just have one last line of questioning for you, Mr. Imber. Mr. Gary, would you mind putting up the other exhibit? So this is the document that was just marked as SC9, but what's on the screen should be an electronic version of the full document. Mr. Imber, I can't recall, did you testify that you'd reviewed this document before?
Yes, I've reviewed this document.
And Mr. Gary, if you could turn to page 326 in the Federal Register of this document.
Ask IT in the back to move to hidden as opposed to everyone.
I can zoom in more too if that helps.
It's just the 1 second. Can we move this to hidden, please?
Sorry, Council, 326.
Yes. Should be page 87 of the PDF. Are we able to proceed, Your Honor?
Please do.
Okay, thank you, Your Honor. Mr. Imber, up on the screen, there's a paragraph that begins, it's on the left-hand side, the EPA proposes. Do you see that paragraph?
First column, left-hand side?
Yes. Are you there?
I'm sorry, what
Are
is
you there?
requested?
Are you looking at that paragraph?
I see it, yeah.
And do you see a few sentences down? There's a reference to a January 1, 2031 deadline. Do you see that? It says, the EPA proposes that affected sources must notify the EPA by January 1, 2031, which pathway they are selecting and thus which standard they intend to comply with. Do you see that?
I see that, but as I read this paragraph, I do not understand which of the three aspects of the rule we're talking about.
Subject to check, are you aware that this proposal, this is the proposed new greenhouse gas rules, correct?
Yes, it is.
And I believe you've testified that there are at least 3 rules contained in here, correct?
Yes,
And one of those rules is a 111B rule that applies to would apply to new NGCC units, correct?
Yes.
Are you aware that the proposed rule sets a deadline of January 1, 2031 for the companies to notify EPA as to which of the compliance pathways for the new NGCC units they intend to follow?
I'm aware of this language and understand it, but in and of itself, this paragraph does not explain all of the obligations to 111B as to the phasing.
That's right. So you agree that the rule sets this deadline for notifying EPA of the compliance pathway?
I agree this says this, but in other areas of the rule talks about applicability, and the applicability being different based on annual operation. So this in and of itself does not tell us the applicability of a unit in the greenhouse gas 111B natural gas new source performance standard.
What other information would you need to determine the applicability to particular units?
You would need to know the annual capacity factor of the unit for the compliance period. That meaning each year, what your capacity was and what aspect you would of base load, intermediate load, or low load you would be applicable to you as an operator.
And you don't read the language here concerning the 2031 deadline as requiring the companies to decide by 2031 whether or not they intend to opt into the intermediate load compliance pathway?
No, I do not read that in this case. This is more akin to whether you're going to operate via hydrogen or CCS, meaning in 2032 taking on the 30% hydrogen obligation, or whether you're going to delay and take on the 2035 90% CCS obligation, if I interpret this rule correctly. The intermediate base load, low load issue is actually an annual operational variable.
And is that something that, in your view, is spelled out elsewhere in this document?
And in supporting documentation, yes.
One moment, please, Ron. I believe that's all my questions, Mr. Imber. Thank you for your endurance today. Mr. Corman?
No cross.
I do, thank you, Chairman. Mr. Imber, are you aware that the Sierra Club's position in the case is to retire the 4 coal plants totaling 1,500 megawatts and to not grant the CPCNs for the 2 natural gas plants?
Objection, Your Honor. The Sierra Club has not yet put forward a position in this case in a post-hearing brief. We've had testimony from experts
I'll
about aspects
rephrase.
of the case.
If the commission grants the retirement for the 4 coal plants totaling 1,500 megawatts and denies the CPCNs for the 2 gas plants, that would in fact reduce the company's environmental cost and risk, wouldn't it?
I'm going to repeat the question to make sure I heard it. If the company's retired those 4 coal units, and did you say installed or not installed?
And don't build the 2 gas plants. Would that reduce your environmental risk, cost?
No, that would not reduce our environmental risks or costs.
Why is that?
If we continue to, I'm sorry, not retire coal, right? Not retire coal.
No.
Oh, we do
You
retire coal.
retire all the four coal plants, and you don't build new gas. Wouldn't that reduce your environmental risk, because you retired 4 coal plants?
So, I mean, on its face, it would reduce our environmental compliance costs. Yes, it would reduce our environmental compliance costs simply because we're not operating assets.
Okay, wouldn't it also mean, however, that you wouldn't have enough electricity to serve your customers?
That would be, yes, that is a true statement.
Okay, so the trade-off between environmental risk and serving customers under that hypothetical.
Yes,
Are you aware that the cost of the SCR on Gent Unit 2 is $126 million?
I'm aware of that number, yes.
Okay, for a 495 megawatt plant, that's about $250 per kW.
Those numbers are all familiar.
Okay, that's about 1/4 of the cost of a new combined cycle.
Order of magnitude, I would agree with that statement.
If the commission denies the request to retire Gent 2, given the Good Neighbor Plan and all the other EPA rules and ways to address NOx, if the commission denies the request to retire Gent 2, is it foreseeable that the company would be in for a CPCN at some point in the future for an SCR so that the plant could continue to operate?
Yes.
I want to ask you some questions about Sierra Club 7. I think, do you have that in front of you? Is that EPA memorandum?
Yes, I have, yeah.
Okay. Am I reading this right? I know maybe you just saw it for the first time. Page 3 of the document where it says unit level cost estimates for FGD wastewater treatment under regulatory option 1. Do you see that?
Yes.
Okay. For the Gent units, it has a capital cost and an annual O&M cost of 0. Am I reading that right? Does that make sense under this option? If there will be no cost impact on Gent units?
Excuse me, Mr. Kurtz, what page are you
The
reading?
third page of the document. It's regulatory option number 1.
So this is I'm not familiar with this document very well. So regulatory option 1 appears to refer back to page 1, the first or column labeled 1. CP, I don't know what CP is. LRTR, I don't know what it is.
Whatever it is EPA saying it would have 0 cost to the Gent, each of the 4 Gent units?
It's saying 0 cost if this technology was implemented at the unit. And so for FGD wastewater, so it would have to be, well, not I don't know what, NA, high FGD flow facilities, LUEGUs, that's not Gent. EGUs permanently ceasing coal combustion by 2028. Technology basis is surface impoundments. Early adopters permanently ceasing coal combustion by 2032, not subcategorized. Bottom ash transport system, high recycle systems.
Your Honor,
I'm not familiar. It amazes me, I guess, that there would be $0 for compliance, but I don't understand this document.
Mr. Riggs?
Your Honor, I'm recognizing the commission's objective to go to 5 o'clock, and I still support that objective. But can Mr. Ember have a 4-minute break? He is exhausted.
I'm happy to give him a 10-minute break if you'd like it.
He needs a break.
That'd be fine.
He is exhausted, and I think that's
I think that.
reflecting in his ability to focus.
I think, do you have very many more questions? Mr.
Probably 5 or 6 minutes, but I'm fine waiting till after the break. 7 minutes, I don't know.
Well, here's what my recommendation is, Mr. Riggs, is for Mr. Kurtz to ask as many relevant questions as he would like in what sounds like a less than 10-minute break. And then, once Mr. Kurtz is done with his cross-examination, we go ahead and adjourn for the day.
I appreciate the objective that you're trying to accomplish. I'm just trying to protect Mr. Ember, and I think that his focus is failing at the moment.
I understand. I appreciate it, but I think that, let me ask Mr. Kurtz, I don't even think this is not a document that's in the records. Do you intend on introducing it?
No, I thought it was Sierra Club 7. I thought they introduced it.
They do not. They asked us to take notice of the document, which we have not yet done, pending a filing of the source information.
Can I just ask one more question on the document?
Sure.
If you go through this under option 1, Mill Creek, 0 cost, option 2, Gent, 0 cost, Mill Creek, 0 cost, is this making sense? And then you go back further, option 3, $4 million capital cost, a couple $100,000 annual O&M. Is this making any sense that the compliance cost for this supplemental ELG would be so minimal?
If this is what the EPA contends compliance costs to the 2023 effluent limitation guidelines, it does not make sense to me.
Okay.
All right, so we'll take a few minutes.
Thank you, Your Honor.
We'll just go off the record. If people would like to get up and walk out, if they want to stay where they are, that's fine. We'll just take about 5 minutes.
Yeah, thank you, Your Honor.
We're back on the record in case number 2022-00402. Mr. Kurtz, do you have a couple questions you said?
Yes, a couple more. Mr. Ember, Gent is 4 units, correct?
Correct.
And for SO2 compliance purposes, does EPA allow you to average out the pounds per MMBTU SO2 emitted to get an average rather than looking at individual units?
Yeah, in the break, I was able to look at our Title V permit and remind myself what's going on there for SO2. And yes, we average our SO2 across those units to comply with our Title V permit. And the basis of that is the mercury and air toxic standard.
Okay. Mill Creek, assume this hypothetical, Mill Creek 1 and Mill Creek 2 retire, and the gas plant is built at the Mill Creek site. Do you have that in mind?
Yes.
What would that do to Jefferson County?
I can't say necessarily that it would cause Jefferson County to go into a tank.
Is that a big NOx emitter? Question, let me start again. Will the natural gas combined cycle at the Mill Creek site have an SCR?
The natural gas being developed has an SCR, yes.
Will the natural gas plant at Mill Creek have a significant NOx impact?
It will have a significant reduction in NOx from the site upon that context of retiring Mill Creek 1 and 2 and implementing that natural gas combined cycle, yes.
I get it on the netting. What about just on the standalone? How much NOx does a natural gas combined cycle plant with an SCR emit?
I would, subject to check in what we've got in our permit, I would say it's in the tens, close to 40 maybe.
Is that pretty small?
It's pretty small.
Is that a small amount?
Yes, it's a pretty small amount, yes.
Okay. Last question. Brown, assume that Brown 3 retires and a natural gas combined cycle plant is permitted on the Brown 3 site. Will your permit have a date by which the new natural gas combined cycle must be built? Does it sunset after a while if the plant is delayed through litigation or construction delays? What happens to the date if the actual plant is delayed?
So we'd be required to start construction within a period of time, or the permit would be would be lost. Actual commencement, I'd have to double check. I don't know that there would be an end point on that directly. We could extend it if necessary.
Just trying to understand as a practical matter. You get the permit, somebody challenges it in court. You have to make a business decision whether to start construction so that the permit remains valid or not start construction. That's a question. Is that how that would work?
Yeah, yes.
If you put one shovel in the ground, does that constitute starting construction? How does that work?
Permanent structures constitute construction. So rebar and concrete would be construction.
Okay, so but the permit itself would have a date. The plan on the table here is new gas plant in 2028. Is that what the permit would say, 2028?
The permit would say well, that's when we've requested the operation. So, but it would be tied. For Brown specifically?
Yes.
Yeah, it would be 2028, yes.
What if construction delayed until 2029? What would happen?
We would apply for an extension of the process, of the permitting process.
Is that common or uncommon, the extension?
It could be common.
Chairman, thank you.
Mr. Howard, any questions?
No, Mr. Chairman.
We have no further questions, Chairman.
I have just a few, Mr. Ember. You filed your Title V permits with the Energy and Environment Cabinet approximately the same time you filed this case, right?
That is correct.
So under the presumption that you would receive, that the companies would receive the CPCNs, correct?
That is correct.
Okay. Those occur about the same time, within the same time?
The timeline for publication of the permit is this fall, and the timeline for this case is also this fall, so yes.
Well, no, I meant the filing, like, do the folks, when I say up the hill, do you know who I mean, up the hill, the Energy and
I'm
Environment
assuming
Cabinet?
you're talking about, yes.
Okay, you deal with them a lot in your position, I see, right? Okay.
Yes.
Did you file your application or notify the cabinet of your application for the Title V permits for the two combined cycles approximately the same time that the companies tendered their applications in this case?
Yes, the same time.
Okay. So I guess just big picture from your perspective, did you appreciate? How do I say this? It's not a surprise to you then that needing those that commission approval for the combined cycles is a prerequisite for actually needing the permits.
Can you repeat that, please?
Yeah, so the commission ultimately was always going to decide whether you all should receive certificate CPCNs for the combined cycles as to whether or not the permits are actually needed for those combined cycles. That's not news to you, right?
No, not at all.
Okay, I just want to make sure. I have a question about power plants that don't particularly have the environmental controls necessary to operate at a given time. So, can all of your power plants operate every hour, just from environmental control purposes? Can all of your power plants operate all of the time across the system, regardless of, without regard to environmental compliance? Let me ask you this way: do you have any power plants that can't run a certain number of hours or through a certain time of the year because they don't have certain environmental controls, or they emit a specific amount or an excess of an allowed amount of criteria pollutants?
Yes, one example would be Patty's Run. We have a synthetic limit on that permit.
Okay, great. So I just asked big picture. If some black swan's probably it, but some significant event occurs, a Winter Storm Elliott type situation, and you've run out of, you're unable to run a Patty's Run because you've run out of allowances or whatever it may be. Can you receive waivers to do so for reliability purposes from either a state agency or a federal agency?
The answer is yes. There are emergency protective orders for operating, but you're still subject to addressing those non-compliance issues as a result. I mean, it's kind of a get out of jail free, but not guaranteed.
It's a keep the lights on, but there's going to be some cost after the fact. Is that right?
Possibly.
Okay. Or there may be some follow-on impact.
Yes.
So, okay. All right. Great. And did you all have any of those during Winter Storm Elliott? Any requests that you all sent to EPA for waivers?
No, we did not send any to EPA for waivers. I was in communication with the Energy and Environment Cabinet about some potential concerns, but no, we did not apply for anything or receive anything directly.
Okay, and I just real ignorance here, like this conversation around Gent 2 or even Mill Creek 1 and 2, whatever it may be, that this whole thing about allowances and whether it resets and it's based on heat rates, and you were talking earlier, I think your answer was, there's a concern about being out of compliance without the SCR because you've got to you're emitting more while you're starting up the couple hours or however long it takes to start up. Do you remember that line of questioning generally?
Generally,
Okay. There's, if any of those units existed without SCRs, post, I think it's maybe 2026, whenever the compliance period is for the NOx concerns with the SCR, and they can't run during ozone season. Like, just assume that's the rule. They cannot run during ozone season. You're out of allowances, and the risk of a loss of load event is very high. Does there exist today the opportunity to request a waiver from the EPA to run those uncontrolled units during ozone season if it's necessary to effectively keep the lights on?
there is a process. I think it might be under the Federal Power Act. There is a process.
And you go to the
Not super
administrator.
familiar. We don't implement it I don't know. I've never implemented it myself.
Yeah, I just was curious. I mean, you all have never had any EA3 rolling blackout situation either, though, right?
No.
You wouldn't have necessarily had the need to figure it out, I guess is what I'm asking.
That's all true.
Okay.
If I may, in the context of these units, if they're sitting there cold, the ability to get them up and running would be a significant challenge
Yeah.
in a timely manner.
Okay. I still don't think I fully understand your hesitancy or let's do a progression real quick on 111. You were talking earlier about, you're, I take it, fairly confident from your testimony, something's going to come down with regards to NOx. See, one way or another, I think I'm paraphrasing your testimony, one way or the other, the EPA is going to have some more stringent NOx requirements on the 3 currently uncontrolled power plants, right?
Absolutely.
Okay. And you're confident of that, and I think the testimony you provided earlier was basically, look, this is a rule that's been around for a while, they're just making it more strict, is that right?
The cross-state air pollution rule is getting less NOx allocations to drive attainment to the lower standards, which is getting lower again possibly next year, so yes.
But I guess what I'm saying, your confidence, I gather your confidence from that is that it's a rule that's been around, it's just lowering the level, it has a proven BSER that you've already applied and installed on multiple units for very many years. Those are kind of things that give you confidence of that proposed rule, the eventuality of that proposed rule, is that right?
Yes.
Okay. Then moving to the 111, the GHG, or the NSPS, whatever it is. You noted earlier you have maybe less confidence. I guess I want to know about the eventuality position, kind of like you were talking about with the cross-state air pollution control. Like, it's an eventuality. They're coming for NOx one way or the other, right? Do you think that it's an eventuality that under the Clean Air Act, this is just based on your experience, given your position, do you think it's an eventuality that under the Clean Air Act, the EPA will regulate CO2?
Well, first of all, they are regulating CO2 today. Maybe not in the way that you're thinking of it right this second. There is an existing 111B coal rule and natural gas rule today. So all new units have to comply with that.
Yep.
Okay. As it relates to 111D, it is a tremendously contentious subject. As you know, it went to the Clean Power Plan, went all the way to the Supreme Court. It was, the Super Bowl of environmental regulatory issues, by all means. I believe that we're going to be arguing about greenhouse gas for a long time, and it's speculative as to exactly when or how it will come into play, but the rules that are put in place today definitely drive and align with the natural gas units that we're suggesting, you know. Like,
Right, but people in this case are arguing about NOx, and as your testimony indicates, that ship has sailed effectively, right?
the NOx ship, yes, I would
Okay.
agree with that statement. I should
Okay.
essentially use the same term I did
Yeah.
earlier
So,
today. Yeah.
so what I'm trying to have an appreciation for is what informs that opinion of yours, right? So, have you ever heard of the case Massachusetts versus EPA?
Yes,
Okay, and it was with regard to not power plants, but cars or transportation, right? Okay, and it, sorry, you have to actually.
yes. Well, I wasn't sure if there was a question.
It's okay.
Sorry.
Assume every statement is a question, even if it's a statement. I'll raise the sound of my voice at the end, so it sounds like a question mark. So, have you ever seen that section of the Clean Air Act related to transportation or cars about any air pollutant?
No, I'm not familiar.
If it was about any air well, 111D talks about any air pollutant, right?
Yes, it does, yes.
Okay. All right. And so I guess I just want to have an appreciation. Do you have confidence, from your understanding, that the ship has sailed on whether GHGs fall under the category of any air pollutant?
Well, I'm not a lawyer.
I'm not asking for legal.
But
You're
I
the
will
only
say
person here to
the-
talk about the environmental stuff, so I got to ask somebody.
The Inflation Reduction Act actually defined carbon dioxide as a pollutant. So there is a backdoor now that the EPA could use and references that CO2 is a pollutant. And under that construct, yes, 111D CO2 could be considered a pollutant.
Yeah, and I'm just trying to find out where you think the fight is, like where the legitimate fight or concern is. Like
Okay.
like is it definitionally under whether it falls under any air pollutant? Is it whether there's a endangerment finding to then, if it's an air pollutant, you have to find an endangerment and then the rule? At what point in sort of that progression do you think the conversation is that gives you confidence that maybe the risk isn't there the same way it is on the NOx rule?
So a couple things. Number one, the terms achievable and adequately demonstrated are the big, hitters, so to speak, in the debate right now.
Sorry, so just so I can be clear about that answer, it's a focus on the best systems of emissions reduction is what you're talking about, right?
The best system of emission reduction.
Okay.
Achievable and adequately demonstrated. The hydrogen and the carbon capture and storage, specifically to natural gas. Could be carbon capture and storage specifically to coal. So that's the first item. The next item, I think there will be a lot of contention as going back directly to EPA versus West Virginia and it just escaped me, the key term.
The major questions
Major
doctrine.
questions doctrine, yes. I fully expect that's gonna be a huge debate. As, this rule clearly drives retirements and changes to lower emitting sources. So, yeah, I think those are the two things. The BSER, achievable and adequately demonstrated, and major question doctrine.
And the major questions doctrine just because of the impact or the way it gets to creating the rule? Well, and let me withdraw that question. The major questions doctrine came up last time in large part because there was the inside the fence argument, right? That was not an inside the fence best systems of emissions reduction. Is that generally the argument?
Yes, part of the argument, yes.
Okay.
Yes.
That's not the case here. Just from that expectation that you're forming there, what is the concern or what raises is it the outcome or is it something about the rule individually that raises your concerns around whether it implicates the major questions doctrine?
Is it the outcome or what was the second part? I'm sorry.
Or the way the rule was written you said something about retirements, that it forces retirements and therefore could possibly implicate, and paraphrasing, possibly implicate the major questions, Doctor. I'm gonna ask this directly. Is that formed based on your conversation with attorneys or individually formed?
I think that is formed from conversation with lots of experts across the country on this topic.
All right, that's fine. So the 50% capacity factor that was modeled in, I think, 5.2, Commission Staff 5.2, based off what you heard from either individually what you know or what you may have heard from Mr. Wilson yesterday, do you know whether the assumption of how that was modeled as a 50% capacity factor was like only running it at 310 megawatts all the time, or whether it was running it so that on an annual basis the capacity factor was 50%?
Well, I should defer to Mr. Wilson, but his testimony, I think yesterday, talked about it was available to operate full load at any time, but
Yeah.
trimmed back from an annual perspective of a capacity factor.
Do you know if I had a question as to whether that 50% capacity factor impacted its emissions rates relative to it being unconstrained, something like the 80% that Mr. Wilson testified? Do you know who I should ask that question of?
So I guess I'm not completely following the question.
All right, yeah,
The
so-
emission rates would be, the emission rates would not be different. Like, if we're talking about mass or rates,
Well-
emission rates would not be different.
Well, okay, well,
Or wait, maybe we're talking different things.
yeah,
What
maybe. That's what I'm saying.
emission
Let's take
rates
a
are we
big step
talking
back.
about?
You talk about how 1,000 pounds of CO2 per megawatt hour is a very, you refer to it as a fairly, you don't say these words, but it's a fairly important, it's a characteristic of the proposed combined cycles, right? That they emit less than 1,000 pounds of CO2 per megawatt hour.
So are we talking, so just to be completely clear,
Yeah.
are we talking 111B aspect with the new rules or 111D with Cane Run or,
We'll just go to your testimony.
okay?
How about that? Just to make everything easier on
Yeah.
everybody. Your direct testimony in this case. I think you specifically talk about the heat run of, or the emissions of Cane Run 7. Maybe it's your rebuttal testimony, I'm sorry. Here we go. It's your rebuttal, I'm sorry, Mr. Lockyer. It's page 17 of your rebuttal.
Sorry, Your Honor, what page?
17, 1-7.
Thank you, sir.
Are you there, Mr. Ember?
Yes.
At the bottom, you see that you reference the 1,000 pounds of CO2 per megawatt hour standard?
Yes.
Okay, and that's the standard without hydrogen co-firing?
So,
And that's, sorry, I'm gonna get to the part that
okay,
you're
I'm
asking.
sorry,
That,
yeah.
you refer to that as being the standard without hydrogen co-firing, right?
so is that a question? Can I? Yeah.
Well,
Okay. So I want to
you
be
use
clear.
the-
This is 111B.
That's the next question.
And that's.
But it says without hydrogen co-firing at the end of the sentence, right?
Yes.
And is that to be 111B or with relation to 111D?
So So we are talking about I believe we're talking about the new unit. Yes, I mean, this is talking about the new units.
That's right.
So this is
Well, no,
specific.
I'm sorry. Yeah, the
111B.
reference to the NGCCs at issue, those are the two that you're requesting the CPCNs for.
Yeah,
right?
so that would be
And it-
111B.
Yeah, so, but on the next page, so I'm trying to work with me here. Your support for assuming they'll meet the 1,000 is because Kane Run 7, which is old news, old technology, right, is already at 800, right?
That is correct.
Okay. So then I want to go back to your direct. At 6. And while Mr. Lovecamp's going there, I just want to make sure I have an appreciation. Are those emission rates of CO2 impacted by how the units themselves are operated? Does it matter if they're at minimum run? Or do they matter if they're being significantly ramped? Or is 800 the average? Or is it the amount that it emits each and every hour regardless of performance, regardless of ambient conditions? Sorry, I know that's 6 questions, so please go ahead.
The 800 is a basis of the annual operation of Kane Run 7. So that takes into consideration its ramping, its startups, its shutdowns, and everything. So it's taken into consideration an annual, and that's how the 111B rule is set up in construct going forward, is to assess operation from an annual basis.
Okay, so that's the context in which I asked that previous question. Does a constraint of limiting a unit of how often it can run, especially at full bore, impact its overall emissions of CO2, pounds of CO2 per megawatt hour? Does running, I was asked this very directly, does running a combined cycle any given year at 50% capacity factor, as opposed to whether it would be unconstrained run at 80% capacity factor, do you expect that the difference in operations between those two facts could affect their emissions on their emissions of CO2 on a megawatt hour basis?
That's a very loaded question. The capacity factor of 50% could mean you're operating at 100% for 50% of the year, or you're operating at 50% for 100% of the year. So absolutely, the question, if is CO2 per megawatt hour a function of the operation of the unit, and what load the unit's running? Yes, it is, but on an annual average, particularly this 1,000, I can't imagine us having a significant problem with dealing with compliance of
Well,
that.
and here's why I ask it, because on page 6 of your direct testimony, let me know if you're there. Do you see line 15 that starts my current expectation?
Yes.
Okay. So the question the attorney asked you is, do you anticipate that the revised greenhouse gas new source performance standards will significantly reduce the CO2 emissions levels in the current standards for NGCC units? That's the question, right?
Yes.
And is your answer, my current expectation is that the revised greenhouse gas new source performance standards will reduce the permissible CO2 emission level for new NGCC units, but not below the level that would make the NGCCs uneconomical, open parent, e.g., for example, by setting a standard that would require carbon capture and sequestration in parentheses. Do you see that?
Yes, I do.
Okay. So, you said that, And that is supported effectively in your rebuttal by the fact that even the old combined cycle, old being a relative term, but old combined cycle is, 20% below the 1,000 pounds of CO2, right?
Correct?
And that you all expect the new ones to even be more efficient than that, right?
Correct?
But K-Run 7 is not being limited by this type of proposed BSCR of a 50% capacity factor in its annual operations, right?
That is correct.
And that type of limitation would, to at least some degree, impact the pounds of CO2 per megawatt hour, right?
To some degree.
Do,
I
do we
can't
know
debate.
to what degree?
Sitting here, I don't know what degree.
Okay.
I would say it's marginal at best. I mean, it's not going to be the types of numbers that would impact this discussion at all.
Yeah, I guess what I'm trying to ask is, how do I find that out?
How do I find that out?
I'm being asked.
Well, yeah, I think, so, perhaps seeing a pound per CO2 per megawatt hour or efficiency curve of the natural gas combined cycles might help you understand what the differentiation is across load profile.
Do you know, based off what you do and the different things the things you do, I'm sure I couldn't imagine, that when Mr. Wilson runs these scenarios, that they give him an idea based off of how often or when units run, what their emissions are for the criteria pollutants that you ordinarily deal with?
Mr. Wilson, his models take into consideration startup and shutdown and take into consideration various loads, but ultimately, I really should defer to specificity of his modeling.
Well, and so the reason I waited to ask you is because this was kind of the basis of your direct and rebuttal. In large part, the conclusions you came to in your direct and rebuttal testimony, like your direct, you remember saying, it seems unlikely that EPA would establish a greenhouse gas new source performance standards for CO2 that would prevent the companies from proceeding with their proposed NGCC units. You remember saying that's on the bottom of page 7?
Yes.
But if the 50% capacity factor actually does change the pounds per CO2, pounds of CO2 per megawatt hour to be in excess of 1,000, that would effectively be a rule that would prevent the companies from proceeding with the proposed NGCCs, right?
Theoretically, the answer is yes, but I mean, the 1,000 pounds per megawatt hour is not impacted by the 50% capacity factor.
So I'm going to just ask as a post-hearing data request, what the emissions of the 50% capacity factor limitation, what the emissions of the proposed NGCCs would be similar to the 5-2 studies. I think this is genuinely my last line of questioning here. Did you all model what the impact of the state, the SIP that the state put in? It's the SIP, of course the state put it, but the SIP that was otherwise denied by EPA on the air transport, the Casper. You know what SIP I'm referring to?
Yeah, I
I'm sorry.
fully understand the question.
There's a half dozen of them. Sorry, I genuinely, did you all model what impact would actually occur for the company? Like what the compliance needs would be to comply with the SIP as opposed to the FIP?
Well, the SIP, as proposed by the state back in, I think it was 2018, did not change the allocations. It was tied to the existing cross-state air pollution rules. So yeah, we understand the the quantity of allocations available under that rule, and we understand our capabilities of complying with that going forward.
I guess what I'm really trying to get to, Mr. Sinclair, and I think I've asked somebody about it already, but Mr. Sinclair noted, I think it was Mr. Sinclair, quoted some of the testimony in the Sixth Circuit. Do you remember that?
I believe my rebuttal testimony has some, but I don't know about Mr. Sinclair.
Maybe it was yours, but basically the testimony from an EPA employee or agent was that the state SIP would have had no impact on NOx.
That is true.
Okay. It's true that that's what they said, or you agree with their assessment?
I agree with the assessment.
Perfect. Mr. Riggs?
Your Honor, in light that it is almost 5 and the desire of the commission to maybe adjourn a few minutes earlier, I'm going to ask for leave to consider whether I have any redirect over the weekend.
That'd be fine.
I should first thing Monday morning.
That'd be perfectly fine.
Okay.
Yep, we can go ahead and adjourn for the afternoon. And come back to Mr. Ember for redirect on Monday.
Thank you, Your Honor.
Okay. So we will come back at 9 a.m. on Monday. I think we will have timely orders with regards to, on Monday, we'll have orders with regards to Ms. McCray and Ms. Grunman. We will start at 9 a.m. on Monday. We'll go late. We'll still take a lunch at 12. We'll also take a supper at 5. We'll try to keep our hour and 15 hour and 30-minute breaks. Is there anything else that we need to take up before adjourning today? All right. We will be in recess till, we'll be on a break until 9 a.m. Monday morning.
Thank you, Chairman.
Thank you.